My lord, I'm being permitted to mention one matter. Listed.
Give the memo.
No, my lord. It is listed in item is 30.
Okay.
The matter is listed with the vacation court. The vacation passed an interim order specifically directed to list the matter on 20th. The issue leads to the appointment of the member.
Don't worry. You wanted to be taken up.
So,
Underestimate the pace of the court.
my lord, I can't.
Yes.
I can't, my lord, sir.
Oh. Give all the memos. Pass on all the memos.
Okay, finish the item.
Resignation item number 1. May have legal also. Well, the events of the petitioners.
Physical construction of the brick kilns. What you are doing?
My lord.
Is a municipality or the municipal corporation?
No, my lord. It is a
environment also.
village area, my lord.
Yes.
Village area, my lord.
So is the panchayat area?
Yes.
Panchayat area. So panchayat is a party department.
No, my lord. My lord is
To make, because they are under the Panchayat Act, there is a provision. If they are doing it illegally, then they can take action. Is it?
No, my lord.
I do not know here what is the law.
No, that is not, my lord. Allegation against opposite partner of
In
my
the
lord.
state, there is a complete mechanism. The Panchayat Act contains all such provisions.
My lord. Here there is no such provision, my lord.
No such provision.
No.
Under the Panchayat Act, has to be. After the Panchayati Raj, this was brought within the constitution. There must be a law. But that is what is required.
But in this case, they have to make party Odisha Pollution Control Board.
After all, this is the Panchayat. Also, they have to take action. So,
And your collector is also made party. He can also verify if they have given one representation. Why is he keeping silent?
it really impinges upon the environmental stability as well. They are flagging a issue. What are you doing?
And revenue inspector has also, I think,
Let them make a part.
revenue inspector has given a report.
What is that report?
Annexure 2.
No, I just read it, sir.
My lord.
I just wanted, I know this report is there.
Yes, my lord.
What he has written?
Here it is written that he has illegally or unauthorizedly constructed a big kiln. And
Well, the report
they are
says
extracting the minor minerals.
well, the report says that he is running the business on his own land. Now the
Can anybody?
Causing health hazards to the nearby.
Yes, sir. If the consent to operate is granted, then he can. Now,
So there must be a permission.
there is a provision.
Is there a permission? He says there is no permission.
No permission has been granted, my lord.
Correct. Now, pollution control board, state pollution control board, is the competent authority issues the consent to operate.
Why, sir? Somebody who is running a mining activity maybe on his own purchased land, but unless the permission is granted by authority, can anybody excavate those are?
It is red brick, Miller. Red brick. Preparation of red brick.
Red, white, blue, whatever. But they are using what? By using what?
His allegation is air pollution, Miller. Air pollution.
Coal.
I am on a core issue that
Yes.
Can anybody commence or continue to do this brick kiln in his own land also? Can
No.
he? If he cannot, then how is operating without the permission or the approval granted by you?
On that part, I have to take instruction, Miller.
That is a major issue.
Yes, Miller.
If it is illegal, it has to be stopped.
Yes,
if it is stopped, then it will not cause any pollution.
And another aspect which is highlighted in this report,
Take
last line,
instruction within two
it obstructs,
2 weeks. Come.
2 weeks, madam.
Yes.
it obstructs the road also.
That's
Puri Konak road,
yes,
it obstructs.
Yes.
Isn't it? That is also
that I've taken instruction.
highlighted.
Yes. Let them take instruction.
So, obtain instruction with regard to representation held by the petitioner by Annexure 1, and also steps taken by the concerned authority in terms of report stated to have been submitted by revenue inspector by Annexure 3. Revenue inspector Chittarajan. List this matter on
4th July. Item number 2.
Published.
Again.
Why you are challenging the demand?
Lordship. Maybe
You are for the
pardon, Your
minister.
Lordship.
the same
If it can
Tahsildar.
come on Monday, Your Lordship. We had sought for instruction, but somehow it has come in another case, Your Lordship.
Tahsildar assumes the power.
Yes, Your Lordship. In that regard, they were saying that these demands are of the period when it was there with the Tahsildar and the revenue was with the this measure and it had not been
The
transferred.
amendment which is brought, it is all retrospective effect or the prospective?
That, Your
effect?
Lordship, if there is anything from the department and all I had asked for, they've
Madam,
given me a
Probably you could not understand what is there.
no.
Once you have brought an amendment,
It is prospective, Your Lordship. It is not
have you said so? Have you said so in the amendment? Because the law is very clear.
Yes, Your Lordship.
Any law which comes automatically will have a retrospective effect unless they expressly intended.
That Your Lordship may give me some time.
The reverse is also true.
Yes, Your Lordship. Because they have given me an instruction in another case, Your Lordship, from the same Tahsildar.
The reason is it's an amendment which is brought. And once the amendment is brought, it will relate back to the.
So why they had
have it specifically provided in the even
yes.
Sir, you have not stated anywhere with regard to pending demands or pending cases which were there.
Yes,
Where
Lordship.
it is that it is prospective in nature.
Yes. As a matter of practice, what I was discussing yesterday, Your Lordship, with the Tahsildar.
No, that is publication will not do.
No, here.
Monday.
They have to say that it will come in force from the day.
Sub-rule 2. Rule 1.
As a matter of practice, Your Lordship, they are.
kindly have a glance at page 26.
But the effect of the amendment whether retrospective.
Lordship, kindly have a glance at page 26, which I have annexed, madam.
Yes, I am looking at page 26.
It says that they shall come into force on the date of publication in the
It's there. Whether it will have a after coming in force will have
even the Tahsildar Lordship and clause 3, my lord. In the said rules in rule 3 in provisos sub rule 3, the words of Tahsildar shall be omitted, my lord. Tahsildar no longer has the power, my lord.
As a what I was discussing. Yes, Your Lordship.
See, the demand is raised after this amendment has brought into.
Yes, Your Lordship. But for the period which was earlier, Your Lordship. So, as a matter of practice, these Tahsildars, they are issuing demand notices.
have another-
So, I have to take it.
You have another notification put in place in tune with this
Yes, Your Lordship.
reorganization of mining department.
Yes, Your Lordship. I
You have another one.
seek the instruction from the department whether they have.
Perhaps you have
Yes,
not
yes.
seen that.
The come ready on that.
Your Lordship, if it can be put on Wednesday, Your Lordship.
Ready
On
with
Wednesday,
the effect of
23rd.
there are 3 or 4 ways of bringing certain provisions into the act. One is by way of an omission. One is by way of a substitution. And third one is by way of an amendment.
Yes, Your Lordship.
And fourth one is by way of an addition. So what would be the effect? What is the general principles of law relating to the statutory operations? in all the four situations. Come ready.
Here it is omitted.
On Wednesday, if it can be taken.
Here it is omitted.
Omitted, yes.
So this omission will relate and have impact over the pending cases or not, or the actions which are not taken yet. There is no saving clause here.
Vis-a-vis section 6 or 4 of the General Clauses Act. You have to take into account that as well.
I
believe section 6 of the General Clauses Act.
yes, sir.
Or 4.
4, I think. Not sure. 4.
The repeal and saving.
6.
6.
I believe 6.
Okay, 6.
Come prepared, Your Lordship. On 23rd, I'll come prepared with all the issues here. For once in
Ready?
on
On the
23rd.
proposition of law. Not an easy task. You'll have to work.
No, since they
And
were
whether this is a substantive provision or procedural provision. The impact of substantive provision by virtue of amendment qua pending cases will be prospective, whereas what would happen to procedural law? Whether this omission is procedural or
Always. It will always have a processual law. It is a procedural law. If it is an amendment is having got, then it will always have a retrospective. A substantive way that is construed to be a prospective instance. Yes. The legislature
specific intended or explicit.
Yes, come on 23rd.
Yes, Your Lordship.
Take it.
Oblige, Your Lordship.
item 9 is also item 9.
Whether she is appearing in 9.
9 is with you.
9 Let come on that way. Next.
Item number 3. Wait, please, Your Lordship.
We list this matter.
But here the petitioner.
Matter at the request of the benefit.
But here
You
the
could not emerge successful in the country.
lot was stayed by this honorable court. Lot was stayed by this honorable court, so that's why I filed an application for refund of my deposits.
So your candidature will go in the event the stay is lifted and they proceed.
No, that time,
Take an undertaking, give an undertaking, no difficulty.
no, that apart, the sale notice which they have issued, that is under challenge, and prior to that,
Probably you could not get it.
Your Lordship.
Sir, there was a advertisement inviting an applications containing certain conditions by way of deposit of EMD or whatever.
Lord.
That
So
is a-
that advertised under challenge in the earlier, another
that
petition.
advertisement is a subject matter of challenge in the petition.
Another petition. There are 2 petitions, Lord.
Whatever.
Yes, Lord.
Sir, there is a subject matter of challenge
No,
in
no,
the
why-
petition.
But why I'm saying that,
Where the court has stayed the further action to be taken thereupon. No difficulty.
yes,
Now the matter has to be decided.
yes,
Please consider. I am
Yes,
giving
Lord. Good, because
just I am giving
That's-
you something to ponder upon.
Lords,
Now when the writ petition would come,
yes,
then there are 2 eventualities.
yes, Lord.
Either the court will say that the advertisement is valid and dismiss the writ petition, lifted the order of the stay, or secondly, it can set aside.
Yes,
Suppose in case the first eventuality,
yes, Lord.
then you have already withdrawn.
Yes.
Then means your candidature will not be considered at that point of time. You give an undertaking.
But why I'm saying that, that shop, the another licensee, he is claiming that shop. So it cannot be go for settlement. In the repetition which is challenged,
You do not know what is a fact.
Lord, I have given annexes. I have given annexes.
It is up to you. You give an undertaking that your candidature will not be
Yes, yes.
considered.
I'm not.
Undertaking in the form of affidavit.
Yes, Lord.
You can't say at the bar that's a conscious decision of the petitioner.
Yes.
Give an undertaking.
But here I have said that I don't want to participate. The influence, yes.
Where? Which paragraph?
Not I have given application.
Of
Annexes 6, page 26, Lord.
These which paragraph you have stated
Lord.
in your writ petition?
Yes, yes. Not para 9.
Show us.
Not pursuant to order 14.2 and letter of the OP number 4 dated so and so annexure 4 and 5. The petitioner filed an application. Yes,
Since that you made an application, it is not considered.
yes.
Show us that your candidature will not be considered. You do not want.
I'll file application. I'll file application.
the petitioner offered his pursuant to the advertisement, the petitioner participated in the process.
I have submitted application.
And,
There is no
participated in the process upon observing all the criteria required therefore. But because of the litigations having ensued in this court by some other person, and an interim order having passed therein, which impedes further action to be taken on the basis of such advertisement, an application was taken out before the authority for refund of the
deposits.
refund of the EMD.
Application fee and EMD, both.
As well as the application fees. But first stop, the authorities have kept the same in suspended animation, having not taken any decision thereupon. The instant writ petition, the genesis of the instant writ petition emerged from the inaction on the part of the authority to take a decision on the basis of the said application. Next one. We find from the tenet of the pleadings made in the instant writ petition that the petitioners intended to withdraw his offer and claim the refund of the EMD as well as the application fees. There is no amendment in the said application on the conscious decision taken by the petitioner not to be considered in the lottery to be held on the basis of such advertisement. Stop. The counsel the petitioner is directed to file an affidavit
7 days below.
Within a week from date. This conveying their conscious decision of withdrawal of their offer in pursuance of the said advertisement, which is a subject matter of dispute in the another writ petition. Liberty to mention after the affidavit is sworn and served upon the counsel for the state.
Yes. Item number 4.
May I please your lordship?
Lord, this is the case, my lord, where
Extension of the lease for 8 years and 8 months.
correct.
Why?
Why, my lord, is the
There
first
any
measure?
clause-
Yes, my lord.
any clause in
Page,
the
page 15, my lord. A state away.
of
Rules
the lease
quoted,
deed.
rules quoted, my lord. This is the statutory lease, my lord, and rules is quoted on page 15. Page 15, my lord. Rule 26(9), my lord. May I read, my lord?
Yes. No, it does not talk about the extension, sir.
Extension, my lord,
does
I am
not talk about
I'm relying on proviso, my lord. It's a
So
first,
also I am all talking. It does not talk about the extension.
my lord, exclusion. I am seeking the exclusion of this period, my lord, because it talks, my lord. Kindly see provided, my lord.
What? Show us.
May I read, my lord?
Yes.
Provided further that the state government may on an application.
I have said, please read the provision. Let me understand
Yes.
my incompetence in this regard.
No, my
Please
lord.
read
Your
that.
lordship is very
Please
much.
read again.
Yes, my lord. lapsing on being satisfied that the stoppage of mining operation was due to the region beyond the control of the lessee, revive the lease within the period of 3 months from the date of receiving the application from such prospective or retrospective date as is.
What is the important one, sir?
Yes, please.
You have omitted to read it. There are two conditions. One is that if you do not operate,
Yes.
then the lease would lapse automatically. The proviso is appended to this rule contemplates that if you make an application and then satisfy the conscience of the authority that the commencement of work or continuance of the work was impeded by some reasons which was beyond your control. Beyond your control.
Yes.
Then in that event, the authority has to dispose of the application within a timeline, and then the discretion is given to the authority that while reviving the lease, it can also stipulate a period to operate from a retrospective or from a prospective date. It may say that it may operate from a particular date anterior to the date of the order. Or will say that now from the date of the order or 1 month after the date of the order, the remaining period or whatever will continue. That is up to him. Has he decided?
Yes, my lord. Kindly see, my lord, this is the rules, my lord, which is provided like.
Has he decided? Has
Yes,
he made an application?
we have made.
Where is the decision?
Yes, my lord. The last improvement order, my lord. I start from the sequence, my lord. Kindly come, my lord. Page 67, annexure P6. I have made this application, my lord.
This probably you have not understood what is playing in my mind. I think I am unable to connect the wavelength of a mind with you.
I am sorry, Lord.
The thing is very small, sir. You need not have to go saying all these things. You made a representation, what ground you have taken, what you have stated. We are not concerned at this stage. You are relying on a particular rule 26.9. Rule 26.9 talks about that what is the modalities which can be done in this regard.
Correct.
Now it is a authority who has to take a decision. I just wanted to know what decision has been taken by the authority. Because you are impinging the decision.
Decision, Lord. Kindly see, Lord.
Decision, if the discretion is vested into the authority, then you know the law that the discretionary order should not be so lightly interfered under Article 226.
Of life.
It has to pass the muster of various tests.
Lord, when we have made
those tests, you know well.
Yes.
So was the law.
Sir, Lord, when we made this representation,
please come to the order.
Let us see. Kindly. Before that, Lord, can I show the two documents only? Page 82 and 97. Then I am coming.
Let us see first.
Which page you are talking? 84. Yes, below.
12/4/2023.
6/6/2023. First, they have passed the lapsing order.
Who is the 12/4/2023?
Page 84 below. It's the 6/6/2023 below.
6/6.
Yes. Page 84 below.
84.
Yes. Before that, below, I would like to clear the facts.
I will hear you.
Okay.
Let us see.
The lapsing order. Yes, my lord. Kindly see, my lord, paragraph 3.
You have
Yeah.
said many activities, the ransom, everything.
No, my lord, I am not saying. This is the report of the collector which additional secretary has sought. Kindly see page 82, my lord. 82 and 97. 82 is the report of the collector which additional secretary has sought, my lord. Kindly, my lord.
Yes.
This is, I am reading, my lord. With reference to the letter of
No, you need not have. I have already read.
92 to
He
2010.
stated that it was 1992, there was, but from 2010, there is no activities.
My lord, kindly come to 97. That is the most important. It's a SP report of the same district to additional chemist, additional secretary. And additional secretary has sought this report from superintendent of police. Lord, my review application, Lord, kindly see, Lord. And what order has been passed
to the authority?
Authority, Lord. Is
At the time of passing the order.
Every time, Lord. In my review application, I have mentioned. And kindly,
You cannot improve your case. I'm just asking you, at the time of original applications, when you sought for the invocation of 26(9),
yes, Lord.
did you mention this?
Right from the beginning, we are saying, Lord, this is the next slide problem.
I understand. Did you rely on these documents at page 97?
Page 97, we relied, Lord. I am relied, Lord. In review application.
For the first time in review.
Lord, the review is in our continuation of original proceeding, Lord. When I came to know, kindly see.
From where you gather it?
Please
tell me this proposition of law.
No,
don't go.
I gather, Lord, at page 97.
Let me understand the proposition. Review is a continuation of the original list.
Yes.
I have
below 97, below.
I have a doubt, sir.
Then another thing, below, I would like to show, below, page 83, the department, very important.
Justify that statement.
Lord,
we have the law.
We have mentioned, below.
Review is a continuance of the original list.
Lord, your
appeal I can understand. Appeal I can understand.
Review is provided under the rules, below.
That is a supplementary proceeding.
So, rules is there, below. Kindly have 46(1) below.
Please look at order 47 of the CPC as well.
No, below, especially provided. A special act, especially provided.
I understand.
Either on record.
When a review comes,
yes,
then the power of review is to be exercised by a common law.
Below,
what the common law says?
Below, right from the beginning, we are saying we are not able to operate because of the.
I asked this.
And I am relying on 26.9.
Then you have not taken up a review application, sir.
That's right. It is
What
known
is
as
not
speaking
taken?
order. Page 122.
And page 97 is a document which must be taken into account.
And because at the time of Orissa, that document was not right.
Whatever, because you relied upon a particular report of the collector, which appears to be very, I would say, clumsy. But when the details have been provided, and that too by a competent authority, then you have to.
You mean to say that collector is unaware of this fact?
No, but he has-
Mr. Counsel, when collector decides mining matter, do you suggest that collector doesn't know with regard to activism?
Yes, he has reported.
What reported? He says that there was a Naxalite activities since 1992 in the area. But he says from 2010, completely stopped. There is no Naxalite the activities there. He has produced a document given by the superintendent of police that in 2010, 11, 12, 13, 14, as many as 38 cases have been registered against the in relation to a Naxalite movement. Planting of the landmines is also found. And your collector does not know anything.
In 2022, I was in Malkangiri. I was restrained to go to a place because many Naxals were surrendering on that day
But by
in that area.
this document, page 97.
Will you consider the review? Will you not consider the review? These are the alarming documents. Your decision was totally based upon the report of the collector. And now he has said that the collector's report is not sacrosanct. It's not correct. Because these are the cases, and the SP has given a number of the cases. The PS case number, the date, if you look at it, all post 2010. And collector does not know. He has not verified from the concerned police station whether any cases have been registered.
Motu and MV79 is a common knowledge. Everyone knows.
And collector has added only another.
Don't rely on a tailored report.
Your Lordship will see 79, 80 and 81, then it's a clear below. Obliged.
Court has accepted.
Obliged.
Why?
Obliged.
Review. The personal order provision. Where is the provision for the may I take?
This is the action. 26.9 below. A review 46.
Is a not a
46.1 below. 46.1.
46.1
rules.
46.1 below.
OMMC rules.
Yes.
Any person agree?
Oh, sir.
Obliged.
Again, the moment you say you will be put in more
I'm sorry below.
you have uttered one sentence, you are put in trouble
Obliged.
without realizing. The decision of an authority, the competent authority, in rejecting the prayer for. For review.
46.1 below.
46.1 is appeal. No.
You have styled your
You know the distinction between an appeal and a review.
Not this.
You have styled your petition as a review petition.
You said review. I just wanted to know where is the provision for review.
Page 104.
104 below.
That is your application. It should have been styled as appeal under Rule 46 instead of that.
Yes, filed it to the sub-collector.
Additional chief secretary to the.
Then he's a sub-collector. If the order is passed by the Tehsildar, then to the collector. And if it is order is passed by sub-collector to the revenue divisional commissioner. And if the order is passed by the collector to the conservator of forest. Divisional forest, then
No, this provision must have been changed, sir, after that amendment. Amendment.
Will not kindly see, will not provide. Provided that in case of matter related to the specified minor
There's an older one. You have after incorporation of this amendment 22.
Your lordship must have 22 amendments.
This is of 2016. In 2022 there are two amendments. In 2022 there are two amendments. After Steels and Mines Department has.
The amendment is not here.
This is by book.
Is it 2025 one?
They put that seal here.
There is the
My book will not provide you what
Sir, same thing, sir. They just this is publisher's devil. He just put the reprint edition without incorporating amendment. He says it
left hand side of your lordship.
Where is 2022 amendment?
No.
Is it incorporated?
It's the same. It's the same. It's incompetent. Actually, what is the what competent authority is the competent authority is changed from the vessel to minor. And that therefore we say within 1 month of the date of the conviction. This is something. I think the vessel has passed it on the pen and through the conviction. This is how the
We have to change this. This is 2020.
sorry.
This is 2020. I misunderstood.
Sorry.
Sir,
No, pardon.
I don't discuss with you. Amendment is sir अलग जगह रखनु जेतले ओल्ड एडिशन दरकार हो सकाळ में मागिले दे
Just also HON'BLE.
What I said?
पूरा बाहर कर दियंतु अलग रखनु सर
Alga ko tole je.
This is something. In relation to the prayer law, the extension and or revival of the expired period of a mining lease is rejected by the competent authority. Which is a subject matter of challenge in the incident petition. The facts discerned from the pleading proceeds that the mining lease was granted to the predecessor of the present petitioner.
Please, bro.
Who, within a short span of the commencement of the said lease, expired, and an application for substitution and incorporation of the name of the son was filed before the competent authority. The mining activities could not be continued because of the several impediments which was beyond the control of the petitioner. So, Rule 26 within bracket 9 of the Orissa Minor Minerals Concession Rules 2016 postulates that in the event the mining activities are not conducted for a specified period, the lease would lapse.
Yes.
automatically without any further reference. However, the proviso appended thereto bestowed right on the said lessee to make an application before the competent authority for a conscious decision to
Revive.
to extend, revive, or renew the lease, provided the circumstances for its non-operation was beyond the control of the lessee. Stop. The said proviso further indicates that in the event the authority finds that because of the circumstances beyond the control of the lessee, the mining operation could not be continued, it may revive the lease either from a retrospective or a prospective date. It is not in it is not in dispute that an application in this regard was filed by the petitioner and in pursuit of deciding the cause made out in the said application, the report was sought from the collector whether the grounds which impedes the operation of the mining activities was beyond the control of the lessee. The report suggests that though there was Naxalite movements in the area from the beginning of 1992, but by passage of time, more particularly on and from the year 2010, there is no such activities. Obviously, the period release comes within that mischief of the so-called no activities, Naxalite movement activities in the said area. And based upon the said report, the authority rejected the said application. Thereby, the lease granted to the petitioner have to have lapse stood confirmed.
Lord, Lord, one argument will.
Section Rule 46 within bracket 1 provides a right of appeal to a person aggrieved by an order of the government authority. But the proviso appended thereto confer an additional right to file a review before the state government within the time stipulated therein. By virtue of the said proviso, the suo motu power to review the order of the competent authorities further conferred upon the state government. Sensing that the review would be the appropriate remedy, the petitioner applied before the authority to review the order of the competent authority, founded upon the subsequent disclosure of the important materials which would impact the report submitted by the collector, having consequence upon the decision of the competent authority. The said review application is kept in abeyance, having not dealt with. Once the person exhausted the remedy provided in the statute, the authority competent to decide the cause cannot keep the adjudication in the adjudication ideal, resulting into the futility of rendering of justice. To stop. The moment the statute ordain an authority to do a thing within its competence, the reluctance in discharge of such duty has a cascading effect on the rights of the parties, as it is commonly as known in a common parlance that the delay defeats justice. We therefore they direct the authority before whom an application for review is filed to dispose of the said application within 4 weeks, within 2 months from the date of the communication of this order. And it goes without saying that that will take into account all the materials which have been disclosed while arriving at the final decision in accordance with law. It is open to the authorities to decide all points, including the maintainability of the review application, if such point is raised by either of the parties.
And that's see page 120.
What?
120.
What?
Impugned order.
That is considered as mistake.
Oh, that this is not proper only.
Page 122 below. I am reading below.
Yes.
Inviting reference to this is the impugned order, Lord, your Lordship has said. In inviting reference to department proceeding number so and so, and your appeal petition dated so and so on the subject cited above, not contain any new material. New material will not SP report. Press hearing.
Sir, you submitted that the review application was still pending.
Not pending. They have decided review.
You said that it was pending.
It has decided it's a non-speaking order, below.
Sir, you said when I started dictating the order, you said that the review, I think all the members who are present were of the view that the review application is pending.
I am sorry, below. It has been decided, but non-speaking order, below.
Then that
there is no order.
That you have taken a court for a ride.
No, Lord, I am sorry, below.
It appears to me.
No, Lord, I have said
that you have not stated the correct statements, which is expected from a very responsible member of the bar.
If Lord, I
and of the legal professions.
I'm sorry, my lord.
I always had the highest of trust upon the members of the bar that whatever the facts they say are borne from the record.
So, my lord,
They
we have
will
said
definitely not say
considered.
any incorrect facts. They may interpret the law in their own way. I can understand that is what is the job of a legal professional. But on factual metrics, I don't think that any member of the bar ever distort the facts and
No,
then
my lord,
make the court to understand or believe.
I'm sorry, my lord, if there is
that I have to change my notion that I carried for more than 30 years, that I repose confidence on the members of the bar, whatever they make the statements of fact to be correct.
I'm sorry, my lord. I said this review application has not considered.
Yes, but it has been considered and rejected.
My lord, not considered, my lord. Kindly.
Not considered. The order is passed. Whether the order is sustainable, order is not sustainable is a different issue.
We have said
non-consideration means there was no conscious decision taken on the review. And he is referring to page 122, 123.
122.
Yes.
And this is the SP report, my lord. Kindly.
He has rejected.
No, my lord. Kindly.
He says the order of C is appealed.
Sir, my lord, kindly see, my lord. I am again reading, my lord. Just for my mind.
I am looking at therefore, the appeal petition filed is rejected, being devoid of merit, and the order issued is upheld. That means
before that, my lord.
Before that,
I am directed to intimate you that the considering evidence submitted with the so-called.
That is the basis of the final order. That may be challenged, that may be wrong, that may be correct. But you cannot say that the review application has not been disposed of.
No, my lord, I have said it is disposed of
You say non-considered.
Not considered.
Pending.
My lord, I said not considered SP report.
Sorry, we are going to dismiss your petition. You are not going.
Kindly, my lord, kindly
consider. No, definitely.
Kindly consider, my lord.
No, definitely.
I humbly request. Even though it's my fault, my lord, I am accepting my. Kindly see, my lord, the SP report has not been.
This is not proper. This is not proper. I have not come across this kind of a thing ever.
No, Lord, kindly,
for my that is the first instance of my career.
No, Lord, I have said
that actually the member of the bar or the legal profession will say something wrong.
We have taken grounds here, and the appellate authority has.
I always have the highest trust on the members of the bar. Always.
Well, Lord,
all the factual matter.
That was not my intention, Lord. When government is here, how can I be, Lord? I can see government is here. So I am saying, Lord, that the SP report has not been considered in the impugned order. I admitted, Lord, that prior to that it was not on record. I have filed along with my review application, and review order has not been considered, Lord. And in that way, your lordship is passing the order.
I tell you very frankly, it is the litigant who will suffer because of you. I do not want that the injustice should be perpetrated to him.
I am sorry, Lord. I'm very much sorry because I only request Lord restore my.
I will dictate the letter only. I have been warned by many seniors not to dictate the judgment in anger, so I am not going.
Obliged, Lord. This is my mistake, Lord. I am accepting. Restore. I only request Lord restore my review application.
I will dictate.
Item number 5.
I beg pardon, my lord. I'm seeking for adjournment. Yesterday, due to some medical urgency, my lord, I could not brief my senior, my lord. The matter will be taken next week, any day, my lord.
Yes, next week.
Item number 6.
Grateful, my lord.
It's my lord. This is the instruction I have received. This was before your lordship 2 days back only. 2-3 days back.
It's on the question of issuance of permit on the basis of fake work orders.
No. Your lordship will find the allegation at para 5 of the petition. Para 5 entire 2 allegations were there. that queries have been auctioned since last 5 years without putting to auction. That answer has been given that it is not correct. Your Lordship will find how
Their advance is illegal activities, the villagers of Bhimkana. So where is the mining activities?
My lords, the ex-MLA has given this. It is given by the ex-MLA, my lords.
yes, sir.
My lords.
Instruction, Your Lordship, may kindly see para 1, 2, 3, 4th para.
Versus PSK.
PSK Infrastructure Private Limited has applied for query permit over the above mentioned plot for the project rehabilitation and application of 4 to 8 landing technical part of section NH 53 from so and so state of Odisha under Rule 34. But no permit has been granted.
Continue.
Sorry, ma'am.
Then why he is continuing with the activities?
No, that's not correct, ma'am.
Okay.
That's not correct. He is not continuing with the activity. Another one, that is Jagabandhu Enterprises. He was given permission. He extracted some more cubic meters. That is why he was fined 20 lakhs 62,910. That was deposited. That is available at the last paragraph, my lord, of that first page.
Now that the permit has come to an end because it was operative till February 2025.
My lord.
Have you renewed or extended?
No, it has not been.
My lords, my instructions is it is till 31st of July 2025, my lords.
No, they have said up to February 2025.
Yes,
I
that
request
is
my
my
senior
instruction.
instructions, my lords. Today morning I have taken instruction from the client, my lords, that it is till 31st of July.
Please go make a physical inspection whether these
Yes.
activities are still continued.
My lords, may see the order of NGT, my lords, in this regard, in so far as this Jagabandhu Enterprises is concerned, my lords. It's very alarming, ma'am.
Right now, my land friend has given that copy of the judgment rendered by the NGT. If that is correct, your lordship may grant me 2-3 days more time so that I can take
My lords,
instruction over this judgment.
Page 30,
rendered by
my
the
lords.
NGT.
May come to page 30 of the judgment, my lords. Paragraph 51.
Yes.
I may be permitted to read it, my lords. In the present case, on the other hand, we find that the work permit stroke query permit order has been obtained by the respondent number 9. My lords, 9 is this Jagabandhu Enterprises. By producing a fraudulent and manufactured letter number so and so dated 29/12/2021 mentioning the period of completion up to 31/7/2023, whereas the actual letter dated 29/12/2021 bore the serial number senior manager so and so number 56/2013 102812, which only mentions that the completion period of the project has been extended up to 31/7/2021 for regularization of pending bills and procurement of material. The period of completion of work itself never extended up to 31/7/2023. The work permit, therefore, having been obtained by fraud, and since fraud vitiates every action, every transaction, the work permit, query permit dated 10/10/2022 is non-nest, and the original application is therefore maintainable in the tribunal. Thereafter, your lordships may see another paragraph, paragraph 62, my lords.
But these are not the allegations in the petition.
Just one.
And it's paragraph 62. So far as the allegation that the query in question is being operated within 200 meters of a gas pipeline set up by the Gas Authority of India Limited, the Joint Committee observed that a clarification was sought from GAIL India Limited from the office of the Tahsildar Gondia. In response thereto, the GAIL has furnished NOC and clarifying that the proposed line is almost 100 meters away from the GAIL pipeline by their letter number 14/12/2020. The Joint Committee has observed that the respondent number 9 was granted lasting permission from the competent authority while order dated so and so. My lords, before the GAIL,
nothing. They did not really stop anything. They say that the matter is relegated to the state for the purpose of ascertaining or deciding the reassessment or a recomputation of the environmental compensation.
My lords, and to initiate criminal proceeding.
So whatever this is in relation, not in relation to this query.
Yes.
My lords, this is Jagabandhu Enterprises.
But not about this query.
My lords,
Sir, we are concerned he may be operating several the queries, but we are concerned with this query.
This is the query, my lord.
There, there he produced a fraudulent document, a manufactured document.
My lords.
The EST, the tribunal was very critical on that.
My lords.
That how can you rely upon a manufactured document when the original document talks about something else and you are relying on the same document which talks about something.
My lords. My lords, then I will take your...
that score it was. But here is the case where they have not taken out. They themselves say that it was operative or valid till February 2025. You are saying that it has been extended to July.
July, my lords.
Now they have to report that whether these activities are still continuing or it is stopped after February.
My lords.
That has to be done. What this GST will do?
My lords,
it's not a
NGT, my lords. This is an order of NGT.
One more
thing. It is not that principle that the falsa uno is a falsa omnibus.
No, my lords, I understand, man. But
they have committed some wrong in some other
place.
That doesn't mean that he has committed wrong in all places.
My lords, another aspect, my lords, which is also important, Rule 37, my lords.
What does not suppose that?
My lords, their own, my lords, now we come to their own instructions, my lords.
The report is submitted by the state, wherefrom it appears that the allegation made in the writ petition against the company who was allegedly operating the query, who was operating the query is not correct. The report revealed that Mrs. Jagabandu Enterprises Private Limited was granted the query permit for a specified quantity for a period from 4th September 2024 to 15th February 2025. It is further indicated that the authorities found the said company to have excavated the excess quantity and imposed the fine as permissible in law, which in fact has been paid.
Yes, sir.
To stop. It is further revealed from the said report that the query permit has not been extended beyond 15th February 2025. To stop. The counsel for the petitioner vociferously submits on instruction received from the petitioners that the query operation is still continuing at the site. Stop. Mr. Das, the additional government advocate, is directed to take unnecessary instruction in this regard and submit the further report on the next date of listing. This on Monday.
My lords, may also see Rule 37 for a moment, my lords.
Only
for my satisfaction, my lords, for a moment. Rule 37(3), my lords. Their own admission is that there was excess mining. The law says if there is excess mining, there has to be a criminal case, my lords.
That is what they
have filed.
That the FIR is lost. He has said so.
Yes.
What is law?
In the instruction, it is not there,
my lord.
Yes.
My lord, may I pray Wednesday or Thursday? Monday, Tuesday, I may not be there. Wednesday or Thursday.
Great.
Item number 7.
May I please, Your Lordship? Lord, the decision of the schedule caste contractor, electrical contractor, applied for the bid, Your Lordship may kindly come to page 16, Annex 1. His bid application was rejected on the technical ground on dated 12 May 2025. The Lordship may not qualify the criteria as per the detailed tender call notice clause 11A.
Where from you're reading the page?
Serial number 5 at page 16.
Your Lordship, page 16, Annex 1.
Serial number
Serial number 5, Your Lordship.
5.
5.
Not fulfilled the criterion as per DTCN clause 11A.
Your Lordship may kindly come to 11A.
Where is that, sir?
That is, Your Lordship may kindly come to page 69, 11, serial number 11. Qualification criteria.
69.
69, Your Lordship. Annex 7. Lordship.
11.
Yes, Milord. Qualification criteria to qualify in technical evaluation. Milord.
A is experience.
No,
Yes, Lord. Yes.
qualification criteria.
A is an experience.
Yes, Milord. Experience. To qualify in technical evaluation, applicants shall furnish the following experience. The bidder should have following experience.
One
Similar
similar type
work
of work
are
under the state government, central government, UT, PSU, or senior government during last 5 financial years, spanning from 2020-21 to 24-25.
Yes.
With a value not less than 40% of the estimated costs put in the tender.
The petitioner also file all those documents, including the experience certificate obtained from the lift irrigation department, where he has rendered your lordship. That is, your lordship may kindly come to page another 3. All the documents, so far as GST and
GST registration is a different aspect. But
your lordship may kindly come to page 35, Annexure 6 series. He has performed the work under the executive engineer, lift irrigation division, Palestine. The certificate given under page 37.
36 is important. 36, the experience certificate relates to 2018, not covering that 5 years period.
No, Milord. In 2021, Milord. Next page, 37, 2021. Executed the following mentioned work under this division during the year 2020-21 and has successfully completed the work.
There.
work order was issued in 2020. So that,
No, Milord. Work order.
there. That shows at least at 27 the work order number and the date that was issued on 16/12/2020.
Milord.
So that is within that criteria of 2020 and 21.
Milord.
Because it starts from an April to a March.
Yeah.
So that you have not taken into consideration.
36. 30 page 36.
Different one.
That is yes.
Your
Yes, I follow.
criteria is at least one work
At least
during
one.
5 years. And what was the total amount was 19 lakhs and 16,000.
Milord.
Does it cover a 40%?
There are
That is
next page, 44 lakhs 799.85.
Whether it is coming to 40%.
Yes, Milord.
Does it cover a 40%?
40%. That is important. It has to be calculated. It is,
Well, no, similar.
No, it is not.
By the Honorable Vacation Judge, my Lord Justice
My
Raman.
lord was a party.
A member of the PNC Lordship.
Notices are issued.
These documents are very clear.
Notices are issued. Notices are issued.
Milord.
Why to keep it pending? Also, that's true. Why to keep it pending? If the document, it's an open shut case. If the document is there, only thing is, did you annex this document along with the tender? That's the first question. That is it. You are annexing with the red petition. Whether you annex with the tender document.
I have annexed all those documents.
Please tell us.
Milord.
Tell us. You are taking a responsibility of this statement.
Milord.
in the
Did
petition.
you annex this document?
All those
tender-
documents has been
tender
annexed.
application?
Yes, Milord.
Did you?
Yes.
Can I get it from any pleading?
Pleading, yes, that is important.
The Lordship may
That is
kindly,
important.
Can I get it?
No, he has written somewhere.
Page 6, Milord. The
Yes.
crux of the matter is that the partnership firm has applied the tender bidding calling for electrical work issued by the works department at Baleshwar with the ample experience doing similar nature of work in previous years.
Yes,
Regards the petitioner's fulfilled criteria as enshrined in detailed tender call notice clause 11A. Hence, the rejection is whimsical,
You
captivated
know which
by
paragraph you are reading.
I am reading it page 6, paragraph 9, Milord.
No,
No, he has not.
this document is annexed. I am
That we have
asking you, sir, very specific question. You are relying on page 37. Whether this page 37 document was annexed with your tender document.
Yes, my lord.
Sure, that's it.
That is page 10, paragraph 16. Petition is submitted in portal both technical bid and financial bid. The technical bid consists of GST in PAN, registration certificate, affidavit, profit loss statement, list of similar nature of work in hands, etc. The financial bid shall consist of bill of quantities and any other price related information undertaking, including rebates, etc.
That's two omnibus.
Experience
What
about
is this? Page 37 is annexure. Annexure 6.
My lord.
All you have dealt with
Annexure 6 is,
experience certificate. The experience we have not written.
yes, my lord. Page 5, paragraph 8. Since the date of firm inception, the firm had worked with the high tension lines having vast work experience. Petitioner done work being attached with the Odisha Lift Irrigation Corporation Ltd, a government of Odisha undertaking. The petitioner successfully completed all the works which he himself involved within the stipulated time. After obtaining the work order from the organization, petitioner from had worked as high tension line or 11 kV electrical transmission lines have undertaken and completed contract of rupees 47.65 lakhs, where the petitioner have successfully worked in the project installation and energizing, including power supply work for Mukuna and Dantuni level 1, level 2 river lift project under Bisoi block, Baleshwar district, where
Yes, that is there. Yes. Yes, that is there, sir. I find. In view of this statement, that he submitted all the documents. Oh, the language is very, very cryptic.
Yeah, that's it is not clear.
Was that
It is not clear.
document was annexed to the
detailed tender call notice.
bid application.
Bid application, we have not reflected that in the bid set.
The moment you show us no difficulty, we'll set aside this order and show us.
The detailed document is there in page 6, Miller. Annexure 3, Annexure 6, Miller.
Where is a tender document shows?
Page 6.
Copy of the certificate. I want a tender bid which you apply.
Tender bid which I applied through online, that copy has not been kept with us.
So you have to show.
Your Lordship may kind got the entire record from the organization. But thereafter, your Lordship.
Subsequent.
Retrieve it
Retrieve it from your system. Must be.
Cannot.
Must be there.
Mr. Das,
Yeah.
is there no provision for retrieving the application document?
No, it must be there in the computer.
Must be there in the computer. Must be there in the computer.
Why don't you download it? And what are the documents they have annexed? Must be scanned documents.
Although it is not been reflected here in the petition in clear terms, but I think he must have submitted. Without that, a person seeking must.
No, you are correct. We are also of the view because the documents which are in possession, why he will not submit.
Yes.
And those dated long back.
only thing I am supposed to examine, my lord, whether the documents have been successful, documents have been duly inspected by the competent authority with full satisfaction of the department. That is the requirement.
He has not.
That is the requirement. He has not reflected anything.
If he has submitted this original, that 37, that itself is sufficient. Authorities have not doubted on the veracity of that the documents, but simply saying they're not fulfilled.
Yes.
Why? There's no reason assigned.
That is why I am thinking, because the authority has said he has not satisfied this clause 11A experience. There a provision is there, competent authority satisfaction must certify it. That competent authority, whether it has been, that certificate has been given or not, why they are harping on this point 11A?
You have not taken that it has not been certified or something.
Yes, that has not
You
been.
say experience only.
Yes.
11A. So we
Yes.
can confine to this. If he has shown the document related to the experience,
then he is
That's
satisfying the clause.
how soon you can produce the document? Just
Only Monday, Tuesday I will not be there. That is why I was praying.
Wednesday.
Wednesday, Thursday.
This the dispute has a squeeze to squeezed into a limited compass as to whether the decision of the authority in rejecting the technical bid solely on the ground of lack of experience can be justified on the basis of the documents annexed along with the bid document or bid application. More particularly, the certificate annexed at page 37 of the instant writ petition. The pleading in this regard appears to be insufficient, having not conveyed the laudable answer whether those forms part of the tender document required to be submitted in terms of the tender notice. The counsel for the petitioner submits on instructions, that those documents forms part of the tender bid
Document.
but is unable to produce the tender application, tender bid as it was submitted in electronic form, and this client would not get an access to retrieve those informations. Since the bid is conducted online, the authorities must have an access to the documents submitted by an intending bidders, and therefore we direct the opposite party to produce the original, the downloaded copy of the tender application along with its annexures filed by the petitioner on the next day.
Can it be on 26th? Can it be on 26th, my lord?
26th.
Thursday.
No difficulty, but whether you will be
2 days I'll be absent, but if it is on 26th, that will be better.
Just the eve of the auspicious day.
Yes, my lord.
I pray I call you on 30th.
For 30th, no objection. 30th, no objection. Because I will not be available 2 days, that is why I am thinking.
Till then,
30th.
some interim measure you are
Measure.
interim measures.
They are not going to do it anything. They are not going to issue a work order. We'll see to it.
Yes.
In
They
that
cannot
order,
in similar matter, my lord says.
will consider. Don't.
Oblige.
Item number 8.
May I please, Your Lordship? Your Lordship, it is that matter wherein the order of penalty was challenged, Your Lordship, wherein the driver of the vehicle produced a permit pass, Your Lordship, but the vehicle was running 4 hours late from the
Yes.
You have to be.
Your lordship was giving to take instruction. I actually concrete instruction I have not received. They have addressed one letter to me seeking some more time. That
Come on Monday then. We can't.
yes, I understood, my lord. That day your lordship expressed
We can't be. Come on Monday.
4 hours late.
Yes, only. There may be several reasons for that.
Your Lordship, I only pray that the vehicle is also seized, Your Lordship. Whether I'll pay the penalty, obliged, Your Lordship.
Item number 10.
Yes. My lord. No.
Where is the order imposing penalty? Where is the order imposing penalty? You are challenging that order under
Yes.
section 10A.
The para 8.
Where is the order? Which annexure?
7. Yes.
Hmm.
32 page. Page number 32.
Annexure
Annexure 7.
7.
That is attachment notice.
Attachment. They have.
What are you challenging? My lord is asking what. Where is the order imposing penalty under section
10A.
10A of the Central Sales Tax Act?
Yes.
Where is that order?
I will challenge that.
Yes.
Who is challenging that? Is
It
there?
is.
Where is that order?
Page 20. Annexure 3.
Annexure 3.
Page 20.
Sir, 2018 order, now you are challenging it.
Yes.
Why? What is the reason why you did not challenge earlier?
We have not done any illegal issue. While discharging.
Sir, the first question is that why you did not challenge that order earlier? After a gap of 7 years, why you are challenging?
We
Revision.
revision.
Where is the revisional order?
That is
Annexure 4, page 24.
23.
Then he has filed appeal against that order.
Against revision? Against revision?
Against revision, he has filed appeal before the commission.
Where is the
Appeal.
None revision.
Oh, that
where it is?
subordinate. That can be. 79.
That is at Annexure 5, page 26. The commissioner's confirmation. Revision after revision. That order is on 11/12/2020.
So on the ground that he has not resold, the
Yes.
C-form condition is violated.
Your Lordship, violate. Section 10D.
So purchased at concessional rate, but he has not resold.
Your Lordship. Your Lordship.
So
Is there any finding that those goods have been given in right to use? Or there is no finding?
No, 10B should be there. 10B and 10D. 10B is also applies, but the authority has not.
10 clause B.
Clause
10
B.
clause B.
Clause B. Clause B, why? Your Lordship, is RC is for cables and set-top boxes for cable television.
No, that is clarified by central government.
Again,
Telecommunication.
telecommunication network. So here cable and TV cable television. So certainly it is not as far as similar.
Television network. That language is
Telecommunication network.
telecommunication.
Communication network.
Yes, yes. That it's
So that interpretation.
no. That central government. Central government notification.
Your Lordship.
Yes.
Your Lordship.
Where is the notification? Where is the notification of the central
Your
government?
Lordship at page 19. Page 19.
19.
Your Lordship. Annexure 2.
Is it revenue's case that set-top boxes he has purchased at concessional rate and supplied it to the subscribers without resale? That is what your case is. So violation of C form condition.
10D.
Would that ipso facto attract 10A penalty? Or there is something more you have to bring on record as a matter of fact, like intention to evade
Your Lordship.
willfully.
Your Lordship.
That language is 10A penalty for imposing 10A penalty.
10A penalty language.
This court has clarified in many judgments. What is that? Mahanadi Coalfield was the last case. So how do you perceive it? Are you satisfied with the commissioner's observations?
And also penalty order. I should not say like this, but the finding is at initial finding is at page 21. The authorities levying penalty and
Maybe now it is.
Well,
Appeal order.
Yes.
And furthermore, can you invoke GST provision for recovery?
I am conscious. I have gone through yesterday evening. I have gone through that attachment
for recovery of CST demand? Can you invoke provisions of GST?
I am conscious. I have gone through. And also 10 lakhs already recovered. Not recovered in you have paid from your cash ledger.
No, recovered, debited by department from cash ledger.
Your Lordship,
Admit.
Let notice the issue, dear.
So you can only have a differential tax under section 8(2), not 10A.
Your Lordship,
You are
let me
entitled
take
for
instruction.
violation of C-form condition. You can only have differential tax under 8(2).
Ma'am, I have gone through
Not
that.
under 10A.
Your Lordship, only since
If they permitted a right to use. If they do not, then what will happen?
man,
Section 10 is a completely different chapter that deals with prosecution. In lieu of prosecution, you impose penalty, 10A. So where is that finding?
Your Lordship,
It has to go.
Your Lordship, let it be admitted, Your Lordship, let me file a small counter. Your Lordship, because three authorities have
After
confirmed.
this,
Let me take instruction.
this court has clarified in very many judgments.
My lord,
So why unnecessarily burdening the docket of the court?
let me take instruction on one occasion. Your Lordship, I admit.
You are an officer. This is a law point, it is not a actual one. And there is no discussion which has been done.
Find difficult. Since Commissioner has confirmed in appeal, Your Lordship, only one occasion.
Commissioner, mechanical proceeded. Mechanical.
Your Lordship, today I am silent. Your Lordship, I know.
What to do?
Let him take instruction.
Your Lordship.
2 weeks.
Yes.
When can he?
2 weeks after.
2 weeks.
Don't insist for any coercive action.
Your Lordship.
Attachment you have done. No, that is illegal. That too, you have invoked GST. How can you?
That should not be. Your Lordship, may kindly grant stay here.
Yes.
Stay the attachment.
Against the imposition of penalty under section 10 capital A of the Central Sales Tax Act 1956 by the Sales Tax Officer, Jajpur Circle, Jajpur Road, wide order dated 7/6/2018. The petitioner preferred a revision under section 79(2) of the Orissa Valuable Tax Act. Read with section 6 of the CST.
Your Lordship,
Of this anyway, 79(2). Read with section 6(2).
Your Lordship.
Read with section 6(2) of the CST Act, which came to be disposed of ex parte against the petitioner by Joint Commissioner Sales Tax. Being dissatisfied, the petitioner preferred appeal. Appeal under section 79(4). 79(4)(a). 79(4)(a) of the OVAT Act.
Again.
Before the commissioner.
79 section subsection 7.
7.
Subsections
of the OVAT Act. Before the Commissioner of Sales Tax.
But that is not applicable, Your Lordship.
After the said appeal.
In fact, the commissioner should not interfere because 79(7).
Mr. Counsel, you cannot argue against your commissioner. Commissioner has disposed of on merits, and you have attached.
Your Lordship, as an officer of the court, I am submitting. Your Lordship, I am supporting or against. The law only I am submitting, Your Lordship. My commissioner has found the mistake. So I am just submitting.
Sir, you have discussed on merits.
Your Lordship.
And disposed of.
That is what he is there. He says that he ought not to.
Commission.
Because that is only applicable for so much revision. Yes. It is revision application filed by the petition.
That's what I am saying.
Lordship,
but after merit, you have attached. They are stuck up.
I am submitting that one.
The commissioner has disposed of the appeal by discussing merits of the matter. After disposal, notices are issued for recovery of outstanding area dues and consequent thereupon. Attachment notice under section. Attachment, this is order, attachment order, Annexure 7 series or attachment
notices.
garnishes also. The department initiated garnishing
Third parties.
79 1
garnishing proceeding by adhering to provisions of OGST stroke CGST Act section 79 bracket 1 bracket C of the OGST stroke CGST Act, wide letter dated 4/3/2025. The petitioner has come up challenging the orders as well as the attachment letter. Sri Sunil Mishra, that standing counsel for city GST, seeks 2 weeks termination to obtain instruction. A year ago, as a listed matter on
7/7.
A year ago, as an interim measure, no coercive measure be taken against the the scope is satisfied that for the recovery of this book all of this satisfied with the fundamental action. For recovery of demand section demand under the provisions of simple self-explain. They did not have this initiation proceeding for attachment by the CGST stroke GST. As an intermediate, the letter dated 4/3/2025 shall not be given effect to pending execution of listed.
Is
Item number 18.
Not to give effect to till the next this proceeding, garnishing proceeding.
May I please look? This is a matter unless the petitioner challenges the first appeal order under GST Act in absence of GST tribunal covered by lordship's order. There's only one small prayer. Here the petitioner has already put the 10% of disputed tax amount Department to verify
Let's see subject. He has
not already deposited. We'll add that line.
Because as per
We'll say that you will have to pay or deposit 10% of the total demand if not already deposited.
deposited after the first appeal order.
That's all. Call the next.
Item 19.
Your Lordship, this is a GST registration cancellation matter.
Yes.
Get you.
Item number 20.
Obliged and lost.
Negligible. This is the matter. The petitioner is a retired government employee, while he is working as assistant engineer.
Order of the CIT appeal or the
Assessment order.
Similar matter, very similar matter. This honorable court has already been issued notice and a fixed hearing matter. Very same matter. Same ITDA matter. He is working as a assistant engineer ITDA. Whatever the ITDA
148.
148A, Your Lordship, an assessment has been passed under section 144.
Deposit in the bank account going to be taxed. That amounts belong to the ITDA, not belongs to the SSC. For which the ITDA has given confirmation letter to that effect as revealed at page
41.
Page 41, annexure 9. Entire amount has been segregated. That is belongs to ITDA. It is not his personal. There is same and similar matter. In another,
Have you seen that?
that is. No. There is same and similar matter. No notice are issued to me, my lord. Whatever notice issued to the State Bank of India. No notice issued to me, my lord. I have only got the assessment order from the department where they are pressing for a demand. I do not know about that assessment, my lord. Because I am a retired employee in 2015, my lord.
Yes, sir. Your Lordship, it's a similar matter which has been earlier heard. Arun Kumar Malik, and is the same another person, Mahendra Kumar Mahanta. Let me take instruction in this matter, Your Lordship.
No course of action. Demand is
Thank you, doctor.
Your Lordship.
What was given there?
Your Lordship.
We'll pass this one. So that's what amendment is the it already is ITD is already party. So that portion is not necessary, that amendment portion.
Well,
Amendment is not required of the pleading because you have already treated him as a party here.
well,
So there is no difficulty. So that portion will not go.
well,
Let them file a counter and all everything.
no
It will be
course
tagged
of
with
action.
that matter.
Well, no course of action.
Correct. It will be tagged with that matter.
All blessed.
Next.
And dispose
Item 21.
Item 21, my lord, on behalf of Mr. Subrat Satpathy, my lord, taken up next Monday, my lord. He's on accommodation today.
2 weeks. Next.
Item 22.
May I please, Your Lordship? During discussion, my lord, appellant had challenged the document had annexed or 5, there is 25/4/25. That
Where
is
is this section 9? Appointment
next
order.
110, my lord. 110 page, my lord. 109, really?
Section 9 is quashed.
Yes, 109
Where is that annexation 9 in the
annexed or 5. 100
5.
page 100.
Judgment.
That is the judgment, my lord.
Sir, that by the judgment, the single bench has passed annexure 9 of the writ petition.
Yes, my lord.
Where is that annexure 9 of the writ petition here? Have you annexed that with your application?
Yes, yes, my lord.
Which annexure?
Yes, 71. Page 133, my lord.
133,
33, my lord.
that is the appointment letter.
Yes, my lord.
Can you read it? I can't read it.
Yes, sir.
What?
My lord.
Do not me.
Madam, my lord.
You want me to read it?
No, I am, sir.
Mr.
Yes, ma'am. Yes, ma'am.
Mr. Are you reducing me to a translator?
No, I am not saying which permission.
You can read, but I have to.
I
read
can't.
That
My lord. That I can say. That I can say, my lord. Yes,
what
ma'am.
it say?
Yes, my lord. My lord. This is the appointment letter issued in my favor, my lord. So, न्यायालय कटक आदेश संख्या नंबर 2 ता 24/11/2023 एवं उप जिलापाल जाजपुर का आदेश संख्या 18,000
Why it is passed?
मतलब
Why the single bench passed?
to that extent I want to draw since attention the judgment by annexure 5 updates relevant page at my lord 119 my lord para 11 my lord may I please
Did you produce a certificate, caste certificate at the time of your application?
Yes, my lord. I am coming. I have produced all the documents which are in pursuant to the advertised.
The caste certificate
Yes, my lord. Yes, my lord. Yes, my lord. For that reason, I want to draw your attention at page 128, my lord. After collecting the applications, the authorities prepared a list, my lord. In that list, they have cut.
That is what the court has held, that there has been some malpractice which is.
No, that is not.
Committee.
That is that extent.
10 marks for this certificate or whatever.
Madam, versus permission to that extent on the self-page, may kindly see the additional affidavit which has been filed with the OP number 4 on the basis of which such an order has been passed, my lord. For that reason, I want to draw also page 118 of the judgment relevant portion of that additional affidavit, my lord, on the basis of which such an order has been passed, my lord. May I place para 4, my lord? That are the last portion. That
Just 1 minute.
Yes, ma'am.
The learning one says that you did not.
Yes, ma'am. For that reason, with Lordship's permission, draw your Lordship's attention, it is in Oriya, Annexure 6 is the advertisement, my lord. permission.
What is the date of the advertisement?
Yes, on 17/7/2017 at page 122. 17/5/17, my lord.
17.
Yes, my lord. 17, my lord. Then thereafter, the last date of submitting the application 3/6/17, my lord. Then thereafter, my lord, it has been categorically mentioned in the advertisement, you have to submit all the documents along with the applications, my lord.
Father does.
Well, they're daily laborer, just like a unemployed person, my lord.
What your father does, unemployed person.
Yes, my lord.
Your father.
Yes, my lord. And thereafter, my lord, kindly see, after collecting all the documents, the authorities prepare the register in which they have given marks, my lord. No dispute at all, my lord. No dispute at all. No, my lord, no dispute at all by anybody else. Only their objection is that I have not submitted those applications at the my lord.
My lord only wants whether there is any validity attached to that certificate or it is valid for all times to come. That is what my lord desires to know.
That
please appraise that.
That document is valid for all times, my lord. Yes, my lord. Only at their contention is that at the time of submitting my application, I have not enclosed. To that extent, my lord, I want to draw attention annexure at page 132, my lord. The assessment made by the authorities after collecting the documents, my lord, after receiving the application, all the documents, they are giving marks.
There is no dispute
yes,
that the selection committee awarded you 10 marks.
Yes, ma'am.
But the challenge is made that the selection committee have done some mischief in awarding 10 marks when you never submitted the caste certificate along with your application.
Yes, ma'am. To that extent,
which head that yes, you never submitted the caste certificate. There was some mischief done by the selection committee in awarding 10 marks. Hence, your appointment is liable to be cancelled. You are relying on a selection committee's awarding of the marks. There is no dispute. He awarded you 10 marks. But this was done illegally.
That is their contention, madam.
That is what the ultimate.
Yes, ma'am. To that extent, I with lordship's permission, to that extent, my lord, that
we have seen the certificate.
Yes, madam.
I do not know, but at the certificate, when you say the case number and the date,
yes, ma'am,
the date is somehow distorted.
No, that is not disputed as well.
Don't go.
No, my lord.
When you approach the court of law,
yes, ma'am,
is it not within the competence of the court to put you certain questions?
Yes, much obliged to that.
Doubts are there in the mind.
Yes, my lord, much obliged.
Have to dispel the doubts.
Yes, ma'am.
Please.
Yes.
There is something which appears. Secondly, come at the bottom.
Yes, ma'am.
There is no signature of the applicant appended there too.
The right side, bottom of the right side, my lord.
Left side.
Left side. Left side, signature of the applicant.
It is not.
But
then it also come down. The copy must be forwarded to DWO. No signature that it was forwarded, which is mandatory under the Act. If any certificate is issued, the copy thereof has to be forwarded to a district welfare officer.
But so far the case note that is reflected, my lord.
The question is whether you submitted or you did not submit.
I have submitted, my lord. I have submitted all the documents along with my application. That is my case, my lord.
Where is the application? Where from it will be revealed that you have submitted a document?
Annexure 8, that is also they have at page 60, my lord. That is very.
No, it's a statement of register, sir. I want your application. No, original application.
That in the at page 60, my lord. At page 60. But it's not 60.
60.
My lord. Not legible, so legibility Xerox copy.
Connection. Page 60.
Page 60, my lord. Got it, my lord?
This is your application.
Yes, my lord.
Show us the annexure. you have appended? What documents you have appended? Show us from this.
My Lord, kindly see.
Show us from this that there is an enclosure or the annexure.
That Yogyata minor is in the same page, that is in the last portion, that is Yogyata, that is not legible clearly, but that has been rightly mentioned. There is a S wording is there. Wording is there in the right side. S minor.
What do you say?
So,
S is there.
She has disclosed the jati. But what about the
see, in, if you go
With respect to that extra, my Lord, that is of the year 2017, my Lord. So after lapse of 7 years, it should be 5. But in this case, my Lord, this person who is 5 has challenged the selection of serial number 1 in the year 2007 after declaration saying that he is not that it's my Lord. That is my Lord. By that time, all these were there, and that was allowed. Against that, the opposite party preferred the writ application before the Honorable Court, and that is confirmed. Then thereafter, writ appeal was filed. All documents were there with the knowledge of the respondent number 5. Then thereafter, when the appointment of the issued keeping register which the marks has been given in the 2024, keeping order to she has no right at all to file such a thing after lapse of 7 years. And moreover, she has said that the appointment, so from the selection she is not fair. That selection of this appellant is not correct at all. There is no such a prayer in the petition. If the selection is correct, so he is.
Where is the prayer?
So, what I like to that extent, I am attacking that.
That was amended.
No, that I'm
I
coming.
find a consolidated copy is amended copy.
Yes, my lord. Whatever.
So was the prayer.
Yes, ma'am. At page 27, my lord. That is a consolidated copy, my lord.
This order of 7/12/2020.
That is the appointment order issued.
That is the appointment order.
Yes, my lord.
They have challenged the appointment order as well.
Yes, my so far the selection they are not disputed.
Okay.
Basic foundation they are accepted. Keeping under 15 of Evidence Act, they are stopped to say anything later on. So far, 150 of Evidence Act, chapter, they are stopped to say anything else because so far as the selection they have not disputed. Only so far as that means foundation they are not, but superstructure they are disputing. That subsequent appointment already issued in my favor after lapse of 7 years, which is not maintained in order to rule true. And moreover, they have
appointment letter is issued in the month of December 2023. They challenge that appointment letter within a very short span of time.
He has not challenged regarding the selection procedure.
That will take care of. Whether that is a very, very vital and
yes, ma'am.
Very important.
Yes. Another thing is that to that extent, my lord, after collection of all the documents, the authorities had made, as for Annex 7, my lord, had made a panel after taking into consideration marks to the persons who have applied for the same or it will be taken into consideration documents. Then thereafter authority is called upon to making a panel list whether they have any objection regarding list which has been prepared. In the same list, it has been categorically mentioned this after before receives that she has submitted the caste certificate and educational certificate. Everything is there, but she has not disputed by that time. She has admitted, even if she has put the signature in the register in which marks have been given to different persons. That is also not disputed. For that reason, I want to draw that attention, particularly the register with the Lordship's permission to want to at page 96, madam. Okay. So far as Pushparani Sahu, she has put the signature on 5/6/2017. And simultaneously, I have put my signature on the self-summary. It has been reflected. I have secured 60 marks. She has secured 58.26 marks. By that time, she has not disputed. Regarding the qualification, regarding the caste certificate, she has not disputed at all. So by the time when she remained silent and after disposal of the unit of will by this filed by the other person who is serial number, then thereafter appointment letter order issued, keeping the order passed by this honorable court, mentioned that out of the list selected person, they have to, she has person, she has to appointment has to be issued. Accordingly, the authority after the selection procedure came to know that I have secured 60 marks, more than the mark of the respondent 5. Then the appointment order has been issued in my favor. Now it comes, now the additional affidavit which has been filed by the CDPO with the Lordship's permission to that extent, my lord, the Lord single judge also reflected in the judgment, the relevant person with the Lordship permission, may I place my lord? That he has a categorical mention, my lord, since these departments are not working CDPO or Rasulpur, ICDS project at the time of selection of an Angari worker in respect of Angari center number 6 of Pratima Khandi, Ramapansayat, she has no knowledge as to what, under what circumstances, because by the time the marks have been given and the certificates have been verified, she was not there. But reliance same. If I have prayed in my counter affidavit, the crime branch or any authority that extent whether it is correct or not. That has been used. And only on the basis of saying that I was not there at the time when the thing was done. So on the basis of the same, this is allowed. So my expectation of keeping with the position so far as the when there is no such a prayer about the selection, not challenged, and the advertisement are made, documents are submitted, authorities called upon making a panel saying that any objection, nothing is done by any person, and the register in which the marks has been reflected of keeping the certificate and the cast, nobody has been disputed, and the prayer which has been made only for selection, which is contrary to the provision of law, common law, and also the Evidence Act. My respectful submission before this honorable court will be the judgment which is the past is not correct at all. That is my respectful submission.
Monday for orders. Monday for orders.
Item 23.
Yes.
May I please, your lordship? Lordship, may kindly see the page 43. That is the order dated 14/5/2025, passed by Honorable Single Judge is informed. I will straightway take to your lordships to Annexure 3.
In fact, what has happened, your lordship, see that is not that bench was not. Page 44, your lordship, that is the ordering portion. My lord, that in fact that bench was not a regular bench. On that day, that bench was not a regular bench. On that day, what has happened, your lordship, due to my lord, the non-functioning of the division bench, Honorable Single Judge was sitting in writ applications, and a list was prepared on that day. But that was not
assigned to him.
On that day. The list was prepared on that.
That day he has disposed of.
Disposed
You
of.
can't say that the person who has been assigned.
No, my submission is not that. But fact remains that matter, I was not there. I was not there to argue. I was not there to argue the matter because I do not know that matter.
Is recorded, sir, Mr. H. Mohapatra.
In fact, matter, I was not there. I do not know, my lord, it was listed on that day. But it is recorded.
Your name is recorded, sir.
It is recorded, but I was not there.
Then you'll have to approve the same judge.
No. Then, my lord, you will
in view of the Supreme Court judgment. In view of the Supreme Court judgment, you'll have to go there.
Then, my lord, on merit, if lordship will consider.
Ramdas Srinivas Nayak.
That's correct. But in on merit, if lordship will consider that, I will not approach that bench, my lord, on that point. On merit, if lordship.
You say that that's a wrong recording of your name, you actually did not appear, then we'll have to approach the same judge.
That's true, my lord. That's true. But on merit, if lordship will go through.
On merit also, that nothing has been decided. You go and ventilate your demands. If there is any refusal, you can come. Here simply says that you want a direction upon the opposite parties to act in terms of a particular circular issued by the Chief Secretary.
My lord.
Nothing. It's up to them whether to decide or what. If they say, I will not act, then you can come.
Yes, my lord.
That is binding. That is not binding. Has to be seen.
My lord,
that circular has any binding effect or does not have a binding effect.
You lordship may kindly see the circular under Annex 3. You lordship may kindly see Annex 3.
Whatever.
You lordship may kindly see Annex 3. My submission is
he says I do not want to go. He says I do not want to go. So
no, I will go there, my lord. If your lordship permits me, I will go there. I will file an application. I will go there.
The order dated 14/5/2025 is assailed in the instant intercourt appeal on the premise that despite the non-appearance of the learned advocate representing the petitioner, the court proceeded to decide the matter on merit. So we had an officer to peruse the reviewed order, which reflects the name of the learned advocate representing the petitioner.
Lordship may simply say that you lordship may
state the court how to write an order. Please have a question. The law is settled in this regard that in the event there is any wrong recording of an event happened on the day, it is open to the litigant to approach the same judge promptly before the event fades from his memory and invite his attention in this regard. It is not open to the appellate court to interfere with the order as the recording of the event or an incident happened in course of a judicial dispensation is regarded as sacrosanct. Stop. We thus do not intend to interfere with the impugned order. However, the liberty is granted to the petitioner to approach the same judge in the event it is perceived that the event which did not happen is recorded to have happened.
Once
Such approach is made, we believe that the same would be decided on merit.
Lordship only say, my lord, I wanted to withdraw to approve the honorable single bench. So that will affect the.
Further right is created in you.
That's true.
That would create something. They have given such more right to you.
Diploma, Lord. Diploma.
It's more beneficial to you, sir. You will job, we will record it.
No, diploma, Lord. You not me record this. No problem. Diploma.
On the list.
Test admission item number 1, CONTC 677 of 2025.
May I please, your lordship, I am in VC, my lord. My lord, here, my lord, the annexure 2 of the contempt application is violated by the contemner, my lord. The contemner.
What was the direction passed?
My lord, here the direction was passed. What has happened in the year 1984? A notification was issued under Section 18 of the Wildlife Protection Act for declaration of sanctuary, my lord. It was not yet, final notification has not yet been made. Therefore, in a public interest litigation, my lord, since the petitioners and the villagers of 28 villages of Puri district are suffering, therefore, my lord, I'm just apprising your background of the case, where, my lord, this honorable court was pleased to direct the contemner.
It is not necessary. We have to find our whether the order has complied with
internal.
It has not been complied with. Your lordship may kindly say.
Sir, it's between a container and the court. You have informed the court. That's enough. Let us hear the contemner.
My lord.
The annexure to start from page 16.
Sir, there was a direction passed in paragraph 9.
Yes. That's what I
order.
Yes, madam.
Which says that the collector will determine.
Yes, madam.
The rights of the persons or the villagers in and over the land comprised in the limits of the sanctuary.
Madam.
And then says that make a public notification.
Yes.
Inviting the claim from the villagers.
Madam.
So have you published the notice?
Yes.
Given it. Show us that what.
Your lordship may kindly see the so-cause filed by us. So-cause.
Collector has filed the so-cause.
Sorry, ma'am.
Yes.
Page 17, internal page 17 of that so-cause.
Internal?
Page 17 of so-cause.
So-cause is at?
That so-cause.
What page?
Plug A.
Huh?
Plug A.
Plug A.
Go.
Plug. Yes, madam. Plug A. So-cause. Your lordship got it?
When the order was communicated to you, sir?
It was.
The order was passed on 21st of September 2023.
Yes, ma'am.
When
yes,
it was communicated to you? Because the first step you took in the month of August 2024.
2024, for the first time a meeting.
Your Lordship is correct.
What, there
That is in Paras.
there is a long gap
Long gap.
in the order. What is an explanation?
During that period, it has not been explained as to how from 21/9/2023.
I am reminding you of the judgment of the Supreme Court.
I'm conscious of that. I'm conscious of that.
Presided over by Justice Kapadia as his lordship then was of the CJ.
I'm conscious of that. Only my
Harassment and lethargic attitude in complying the order is also a contemptuous
contempt. Yes, it is that.
You'll have to explain that why such a long time is taken.
That has not been explained here.
That is one part, and even thereafter, what step you have taken?
That's what I wanted to point out.
You have not taken very seriously.
No, my lords. Thereafter, it has been taken seriously. During that period, yes, that attitude of the opposite party cannot be.
You have taken up in between.
Yes, my lord. You also kindly see page 17, internal page 17 of the Sokaj. Your lordship got it. Para 3. It is relevant from Para 3. The Forest Settlement Officer Puri informed that notification number 9 dated 28/8/2024 was issued to the public inviting objections from individuals claiming land within the Balukhanda Konarko Wildlife Sanctuary. In response, 1,435 applications were received, with 19 cases already inquired into. Given the large number of applications received, it is decided to constitute a joint verification team consisting of officials from both the Revenue and Forest Department, including the Revenue Supervisor, Revenue Inspector of the concerned Tahsil, led by Tahsildar and Forester, and Forest Range Officer to be led by the Assistant Forest Officer. The Tahsildar and Assistant Forest Officer will report to the ADM Revenue Puri. The DFO is
that is in relation to a resolution taken in the meeting held on 22nd of January 2025. Look at it that how long the court will continue waiting for your.
We have in the Sokos, I'm conscious of that. In the Sokos, I cannot make a prayer. Even then, we tried to convince your lordship that 3 months time will
proceed in a snail pace.
I cannot improve upon my lord what is already.
You find out some solution by which you can do it. See, it's a very huge
number
of applications. You can't expect this to be done within a day. And collector being in different assignments,
I'm conscious.
How many days you are devoting for this?
Here we are trying to impress upon your lordship to grant us 3 months more time. Within that period, everything will be finalized. Yes, I concede to the extent that initially they have not
then what
done anything. Sorry,
we are stuck. We are bound by the Supreme Court judgment. I believe 2012.
I cannot improve upon. I cannot improve upon my lord. What has been already
volume 3 or 4 SCC.
But my letter to the department, you must have to carry out the order within the shortest possible time. Now, telephonically, they were talking to me. They asked for much time. I said no. The shortest possible time you give, but during that period, you must have to comply with the order. That is why 3 months time, if your lordship grants me, I am hoping everything will be. Sincerely, I am saying now. I have written a letter to them. It's not, you cannot play hide and seek with the court's order.
My lord, may I permitted to submit one line, my lord?
Yes.
My lord, may kindly have a glance to the last line of Para 8 of the Sokaj. Probably due to such dilemma, the collector is in difficulty to take any decision, my lord. Because they have the entire, my lord, since 1987 till date, they are not in a mood to make it this wildlife sanctuary, my lord. Because it was initially funded by the. So there is a possible of de-notification of the wildlife sanctuary. So therefore, my lord, government probably is not taking action, decision, and the collector is bound by the order of this honorable court. Therefore, there is a, my lord, delay in compliance of the order. So let that be clarified by the government whether they want to continue with the notification or denotification. Because now they have to pay more than thousands of crores of rupees to the people, and they want to make this area tourism viable. So that is the difficulty what I.
So really, you are standing for in the rescue of the contenders.
No, my lord. My lord, I am not. My lord, I am fighting, my lord, because we are suffering since 1987. We are not able to use our land, my lord.
Why?
Because due to Section 18 notification, we cannot use our land.
No.
Even not no sale, no mutation, no tourism, no hotels, nothing, my lord. We are unable to earn our bread and butter, my lord. And it is the place from between Puri to Konark Marine Drive. And the entire villagers of 28 villages, they are suffering due to the notification issued by the third monitoring committee not to use the land.
That matter is over, sir.
They have to either pay the compensation or to denotify.
Not to be taken care of and decided.
My lord.
More concerned with that, whether those objections have been taken care of and decided finally.
My lord. That has not been done, my lord.
You know, the contempt jurisdiction is not a reviewing the reviewed order.
My lord.
So, we have to confine whether there is a willful or deliberate violation of the order. Their conduct is a factor, what they are doing.
My lord, collector in the month of February sought for 3 months' time. Now we are in June.
Yes. What do you say? In February, you asked for 3 months' time. Again, you are asking for 3 months' time. How long the court will continue?
As a matter of fact, I was talking to the officer concerned yesterday only. Yesterday only I was talking to them. Shortest possible time, I advise them. Shortest possible time, you must have to comply with the order entirely. So
No,
that's
in February 2025, you had filed an affidavit.
Yes.
Taking that time, and if there is a considerable improvement in your conduct, then it's all right.
During this period, improvements are there. During this period, some developments are there, my lord.
Small, negligible. Negligible.
And now within this coming 15 days, possibly.
Oh, I understand there were a voluminous claims or propositions that has come.
Yes, ma'am.
But still, you could have come and show that that out of 1,000 or more applications, we have been able to decide at least 20, 50, 100.
Yes, we have stated.
90 probably there. With 90 cases already in.
We have stated so, my lord.
Where you have stated?
Paratri.
Huh?
Paratri, this way. Out of 14,
90.
So only
90 cases have been.
And that too, between the period from 22nd of January.
Correct, ma'am. Correct.
What you have done? After the January, how many more? Tell us.
And this is only 1435 applications. You may receive many more.
We have received.
Navratri is there. Maximum.
Because
we have received 1435.
They can't go beyond.
Right.
Yes. What to do?
I pray your lordship may kindly extend some time and
again for another 15 months. Are you sure 3 months is enough? Because Rath Yatra is there.
Rath Yatra, I was telling that these 15 days, possibly nothing can be done. This 15-20 days. Rath Yatra period, that particular.
So you want a buffer time of 15 days as well?
Pursuant to this locus filed by the no, this is not a SOCUS. This is the proceeding of the meeting. Pursuant to the proceeding of the meeting on the issue, it appears that 1435 cases, applications have been received, out of which 90 cases have already been inquired into. The learned AGA submits that in the event 3 months time is allowed, the entire case can be inquired into and the compliance can be made. Having regard to the size of the applications and the peculiarity of the circumstances with which the collector concerned is assigned with, and the ensuing Rath Yatra, 3 months time is allowed. Just to be talking. 3 months time is allowed for compliance filing in terms of the order passed on in 2023, the order that kindly mentioned. That it is made clear that endeavor be made without further laxity in complying with the direction passed by this court in the review order.
Yes.
My lord, a date may be fixed, my lord.
Yes.
We'll take the
A date may be fixed, my lord.
26th September, 25th September,
July, August, September. So
26th,
25th
of September.
16th Friday. No, fix in the first week of August, because
Right.
this proper time.
Yes,
10 days.
proper 10 days. Right.
We are fixing in the first week of the August. Yes.
Item number 24. Lord, item 24. Lords, may kindly have a glance. Annexure 1.
Review.
Lord, in fact,
Review of whose order?
the order of this honorable court passed in the previous writ petition, in the writ petition, Miller. There are two writ petitions. Miller, both came up for consideration before this honorable court, Miller. In Annexure 1, you will also may kindly have a glance. This honorable court has specifically directed the state government to obtain instruction, Miller, which is a precondition for hearing of the writ petition on merit, Miller. So, a specific instruction was called for from the state government, Miller. Thereafter, the state government has taken several actions.
One subject to the satisfaction. So what review? Sir, I believe that the substantial relief has been granted to you.
No, portion of the relief has been. That was the
portion that they say that refund will be made.
Miller, that was
Subject to the satisfaction.
Miller, that is pursuant to the order in Annexure 1, Miller.
AGA has given this letter is taken on record, that is what we have stated. In view of that, repetition is.
What is the error apparent on the face of the record? Show us.
Miller, your Lordship, may kindly see Annexure, the order dated 14/8/23, Annexure 1, Miller. There, your Lordship, 14/8/23.
That was in a writ petition.
In the writ petition,
but that gets merged with the order of the division bench.
Miller, that division bench order dated 14/8/23, directing the state government to obtain instruction for a precondition for Lordship, may kindly see.
Sir, the moment the division bench modified or whatever passed the further directions,
Yes.
that means that the order of the single bench merged
No, not
the order
single bench, Miller. It was the order of division bench.
The 14
Yes,
So even the law is well settled. If there is any interim order passed, that gets merged with the final order. It cannot remain alive.
That is exactly.
Para 5 of that order shows that
That was
the
the
entitlement. No. Entitlement. We have asked to furnish the entitlement. What is the entitlement? They have furnished a letter that it is the entitlement. We have recorded in the final.
What is the review?
That is
Miller,
you see, para 5. If the state opposite parties calculated the area amount of so and so, which the petitioner is liable to pay by charging interest at the rate of such a
24% per annum is applied.
Demanding the petitioner.
That was the instruction set for me. Thereafter, you will also see the several adjournment was taken at the behest of the state government. And ultimately, a letter of the collector was produced that we are prepared to pay the 20, that is the principal amount which I have deposited.
So subsequent to the order which you sought to review, can a review lie on a subsequent event?
Not the subsequent event.
That is what you say. These are the events happened after 12/1/2024.
12/1/2024
is the order which you sought to review.
Absolutely correct.
Correct. Anything which happened after 12/1/2024, then how? What is the error?
Error means, you Lordship kindly see, the order dated 12/1/24, this Honorable Court has not decided my case, Miller. It is only on the letter produced by the state government.
Now there is a distinction between an order which is erroneous and an order which contained error apparent on the face of the record.
Right, Miller.
Erroneous order, you go higher up, challenge.
Miller.
But an error, where is an error?
Miller.
The court may have decided correctly or wrongly.
Miller.
It's within the competence of the court. If you are aggrieved, you can go and challenge that order.
Absolutely correct, Miller. If there was an adjudication, I am agreed by the adjudication. My remedy is to approach the higher forum.
Here, Miller. But Mayor, if the adjudication appears to have been done in a particular manner, which you perceive that it is not an adjudication, yet it is an erroneous order, no before the higher forum.
Lordship, kindly see.
Look at Order 47, Rule 1 of the court.
Yes, Miller.
What it says? Only on 3 grounds.
Right, Miller.
The review.
Miller.
Where is the error? First thing is where is the error apparent? Second thing is where is the discovery of new and important documents according to you?
No, I don't. I rely upon the two conditions. I rely upon the first condition that
this can't be said to be an error apparent to the
Miller. That if you see the connected matter, that error is upheld. Here, Lordship kindly visualize. There are 2 matters listed. Miller. I filed 2 writ petitions. Miller. First writ petition relating that despite the direction of this Honorable Court, the amount has not been refunded. I was held rather liable to pay further amount. Miller. That was the first writ petition. Second writ petition challenging that though I participated in the proceeding, became the successful bidder, but I was denied with the settlement of the minor minerals. Miller. Both the writ petitions taken together. First order, my lords are pleased to direct the state government to obtain instruction, and in the impugned order, first writ petition, though even disposed of, but this shows that both the writ petition was disposed of. The second writ petition has got no nexus so far payment is concerned. Lordship, kindly see the second writ petition also. It has nothing to do with the payment. It is relating to the settlement of a minor mineral.
Uh, 25.
That is 25 million. 25. Lordship, kindly see that, Miller.
Second review is against which order?
Miller, same order, common order, it was disposed of. Miller, the second petition has got no nexus for payment is concerned.
So second one is next of the.
Since it is a company problem, let us hear both. While you are appealing, there will be better idea.
Where issuing notice? Where issuing notice?
My lords, only one submission, my lords.
Second point.
Yes, my lords, I understand.
Because if the court has not decided anything on that. So file your affidavit.
My counter affidavits have been filed in this matter.
Which matter?
In both the matters, my lords.
Has been filed?
In the read you have.
It's in the writ petition.
No, review.
My lords, okay, my lords.
You are issuing notice of the review.
My lords.
File your counter.
Yes, my lords.
Review. What is the order?
The first petition.
Review has to go. Sir, first will go.
I am really agreed on this.
Yes, it is a composite one.
Absolutely.
We are
so in absence of
in both.
So I cannot maintain a single review, Miller. That is my predicament.
No, sir. So far as the first matter which relates to a writ for refund, no case. But so far as the other, as you said, that there were certain reliefs which has not been taken into account, we wanted to hear them.
But I'm really agree with that.
So, no, sir.
Let us since both
is it still surviving?
The petitions were.
Is the cause still surviving?
Yes, yes, Miller. Otherwise, I would not have bothered you. Lord.
This auction is not finalized, is it?
No, Miller. I was the has to be there. I was not settled. The next man was settled. Miller. My grievance was before your lordship. It has no nexus with the money, Miller.
Whether the next man has already completed the work?
Because of this order,
lease was already executed, my lords.
Notice, counter affidavit by 2 weeks, rejoinder if any by a week, matter to appear after 4 weeks.
Item number 26.
Withdrawal.
Yes,
My please, let's hear what has happened. The petitioner is before this honorable court.
You have filed a withdrawal, ma'am?
Yes, my lords. Yes, my lords.
Withdrawal.
There is one small request, my lords. Here, my lords, what has happened? The petitioner is before this honorable court.
Is a conditional withdrawal or a conditional withdrawal?
No, my lords. No, my lords. There is no condition.
Then no further submission is required.
Yes, it has become infructuous.
That's all.
Yes, my lords. Now, my lords, the petitioner wants to avail that.
We can't give you. If you withdraw, we will not pass you any order. If you want a disposal, we can.
There's one withdrawal memo is there, my lords.
That's all. Then withdraw. Simple. Then next 27.
Item 27.
Item 27, may please, Lordships. Lordships, I'm appearing on behalf of in item 27, I'm appearing on behalf of the opposite parties. Yesterday only I received the brief. I have been instructed.
Is a petitioner.
I am appearing for the appellant, Your Lordship.
Yes. What?
Your Lordship, we have filed this writ appeal, but it is barred by opposite party is a private party. It is barred by limitation, so they have entered appearance today. Another date.
You have filed an application for condonation.
Yes, Your Lord.
Donation with me. Lord, we have not received any delay of condonation or delay in application in that respect.
So you, how many days delay? 95 days?
Yes, Your Lordship.
And what our staff reporter has said?
No, 131 days. 100 days.
What more, sir? Section 5, what do you have to say?
You are appearing for all respondents?
Your Lordships, I'm appearing for all the response.
So, what do
So
you have to
you-
say
you-
about this delay?
No, you file objection or?
Your Lordships, I will seek instruction because yesterday night only we received
With
the.
respect to
Your
limit.
Lordship, both. Your Lordship, both to the delay part as well as because there is a delay of some odd days.
95 or 100 days delay, sir.
Your Lordship, there is 100 days delay.
So,
I may permitted to file a
So,
objection to that.
100 days delay. And the ground of illness has been taken.
Your Lordship.
Is an octogenarian or septuagenarian? Your client? You have said because of the old age?
Yes, Your Lordship, not exactly.
Not septuagenarian. 68 years.
68, then not even a septuagenarian.
Yes.
What a old age? Then he's a young man of 68 years of experience. Where are our documents relating to illness? Anything you said? Anything you annex?
Lordship, we
This is about refixation of pension.
Old age disease. Second file objection. Second person.
What section 5? What do you say?
Your Lordship.
Section 5.
Your Lordship,
What do you say?
Your Lordship, there is a delay of 100 days. Your Lordships, I may be permitted to file a.
Why section 5 is incorporated in the statute?
Because Your Lordships.
Is the length of delay material?
Because as far as I've gone, because I've not taken a single government.
On behalf of correspondence. Okay. Mr. Samsundar Patel. Yes, I got it. Raise for 2 weeks.
Your Lordship, 2 weeks time.
2 weeks of permission, 2 weeks. File objection.
On the meeting of the petition application time, that amount of
What was the?
Your Lordship.
Sir, I hear it. I hear it.
But not only.
Item 28.
In WA. IA 1487 2025 in WA.
The 28.
28.
25 notice was issued through registered post.
In WA.
This was, the friend is appearing for
Lord, I am
petition with the respondent.
to appear for respondent number 2. I'll file my wakalatnama on the drawbox today, my lord. But my lord, there is another respondent number 1. University is also there. Notice was also issued to the university.
Yes, the notice has been issued. Last time it was directed.
Yes, 2-5.
Yes. So this is not complete. Stand over for 2 weeks. Service is not complete.
Again, listed along with another WPC arrange same. I have given the number. Can you list with that so that
It's in you. Yes.
Item 29.
Please, your lordships.
it's number 28.
29. I'm for the petition. There is small note. 2-3 pages. The petitioner and opposition of 5 to 11, they have submitted their proposal for outsourcing deployment of outsourcing personals. Here the condition is that the service charge on HR cost should not be less than 3.85% and not more than 7%. But all the opposite parties, private opposite parties, they have quoted the service charge to below 3.85, and I am the only one person agency who has quoted more than 3.85. The tender is not yet finalized. So I applied on the RTI Act and I got information which reveals that at page 126, the authority has qualified all persons, saying that all of them have quoted 3.85%. Page 126, ma'am. Now in my para 5 and 6, I have calculated the service charges quoted by all the persons at page 8. There is a matter of 1 paisa. The 3.85 is in between 86 paisa, 0.86 and 87.
All the respondents completed. Opposite parties. Good action. Emerson search.
What?
Service.
Reminded of my old days, the school. What a great mathematical calculation you have worked out. When it is more than 5,
yes,
after the decimal.
But man, here round-up theory. But here, this is a tax. Round-up theory is not applicable here, as because my lord, if they will, if we will make reverse calculation, it come down to 3.85. And in similar cases,
it is for we have worked out 3.84999999. So which is nearer to 3.85.
my man, here one thing.
Your contention is that if it is 3.85,
As because my
You say
yes,
below
my
3.85, that's why.
here as because the amount is in between.
If you say this, then our arithmetical notions, which we have studied,
yes,
that goes wrong.
No, my here,
No, yes, you see, if you say 3.84999986
here one thing.
percent,
Yes.
that becomes 3.84. Then my mathematics.
3.85.
No. Here, here what happened?
3.85.
If
That's why I say
if the service
of my school days.
if the service that yes,
you have to prove my teachers wrong.
If the service tax is paid as per the quotation, then it come down to
the quotation, the mandate was they cannot charge less than 3.85.
Yes.
You have quoted. You have quoted
that
the price. They have also quoted the price.
They
While working out the percentage,
yes,
such a mathematical precision you have shown that it will come down to 3.84999798.
So it will be terminated at 3.
So according to you, it is below 3.85.
Yes.
You have calculated very interestingly. Your quotation is 3.8500000182.
My one thing. Here, the service charge cannot be less than 3.85 and more than 7%.
If any numerical number more than 5, then it will be added in the integral to a
in similar circumstances
complete number. So 3.84999999. If it is done, it is
in reverse, it will be if the service tax will be paid, then it will come down to 3.85.
Absolutely, our teachers
and there is a judgment of this honorable court.
Teachers are wrong.
You have to prove my teacher our teacher.
Here the round of 2 is not applicable, and that is the only ground. Then another person will be
Sir, if any decimal value more than 3, the third one will be converted to next higher second digit.
You should come to page 68.
So we are not finding out the trigonometry.
I do agree. I do agree. But what happened?
From
if
up
the
to
amount,
noon, we are not finding the value of
if the service tax will pay 3. Of the gross amount, and in this case cannot be less than 3.85%. In that case, I have quoted more than 2%, and in this case also I have quoted 3.85%. And other quoted 1% less.
That's why I'm saying it was absolutely there will be the open and shut case where it from a very normal way of calculation it exceeds 2%. But here it is so marginal that's negligible.
In this case also same matter.
No. 3.849999. If that is the consideration, then why not it will be treated as 3.85?
I'm giving comparison approach cases.
I don't think so, brother.
Count page 2.
No.
Page 2. There is a comparison of these two cases. That judgment and this case matter.
No, we cannot go into that. The finities of the mathematical calculations and all everything that cannot. I do not know why the reason page in the facts of that case has gone, but the law does not say so. What is position? We decide it.
My lord, my appearance item. The appearance and opposite party number 11 will be noted.
So, Mr. You are appearing for? Mr. Lal?
Opposite party number 11. That is the L1.
Hello.
And number Mr. Sumit.
This is item number 30.
Yes, ma'am. I am for opinion number 2.
What is this?
Well, this is a case, sir. This
You are for?
sign for me. The Union of India and the GST. Yes, my lord. This my lord friend is challenging the first selection of the GST. Sir, just a minute.
And it was passing, and this matter was fixed to go. Yesterday, also by this time, the counter was not served on us. They have in fact served. I have no objection for us to kindly take it up to Monday. In the first half. It should be cost to them.
And Monday,
Yes, at the earliest, I don't think.
it's 23rd.
We can't expect this hearing at this time.
23rd. So, my lord, on
We'll see.
We'll forget everything. That's all
May I permitted, my lord, this count physical copy I am filing because it is not reflected in the. Yes.
Mr. The Paril, that is DSG submitted that counter affidavit has already been filed in the registry.
Yeah, by all my e-filing.
When?
Today. Yesterday, so today. Counter was yesterday, I is today.
Today, what? You have not covered.
Counter affidavit.
Korea, please, sir.
Listen, sir, I am asking you witness.
Serving copy of the same on
ଆପଣ ତ ନେଇପାରିବେ ଗୋଟେ
ଏଇ ତ ଦେବ ମୁଁ ମନା
sir ଆପଣ ସାଙ୍ଗେ କିଏ ଅଛନ୍ତି?
ସିଧା yes brother and so Richard is there.
Why this matter was mentioned in the morning?
Because my lord, this member same come
Taken up. Now we have reached.
Very fast. It is.
This submission item number 1.
May it please pass. The fresh 11.6 application minutes.
Yes.
The arbitration clause minutes is at page 213.
Page
213 of the brief minutes. Clause 87. 213. Would be a part of annexure 7 minutes.
Clause
87 minutes. All disputes or differences whatsoever which shall at any time arise between the parties hereto touching or concerning the works or the execution.
Is the procedure for arbitration.
Well, it's we will have to, any party will write to the
receipt of the name of one of the persons. So have you?
Yes, I have
the section 21 notice.
Yes, I have issued the section 21 notice that is at 246. 246. That's issued on 28th of January, Williams.
What is the nature of the dispute?
Millets, here what has happened, I am a transport contractor. I was transporting coal for NALCO. Now, Millets, the contract period was for 12 months. It was for 1 year. I finished the work in 9 months. Yet they have deducted penalty from my payments.
Because you are working so fast.
No, it has got nothing to do with that.
So you raise the dispute that you can't impose penalty.
Yes, that's my case. They have imposed penalty of 2.3 crores.
Is there response to this?
No response to this.
Who is for the other side?
Plus, it's coming up for the first time. Notice has to go.
Yes, returnable after 2 weeks.
Plus,
item number 2.
Wait for this.
Serve the notice, the copy of this application. I know extension of time. The IA is filed. I have given. Have you served the IA?
Yes, I am appearing for the opposite
Yes.
party.
Lordships in this
Are
matter,
you consenting for extension?
No, here I have raised a preliminary objection regarding maintainability of this
I
application.
understand. I also
that served
anticipated
a
it.
copy of the judgment also on the last occasion. And referring to that judgment of the Honorable Supreme Court, our Honorable High Court has also passed an order, Your Lordships. I will only seek for a liberty to file it before the appropriate authority, Your Lordships, according to this judgment.
So go before the appropriate
Yes,
forum.
Lordships.
Yes, same order.
Bletch.
Item number 3.
May I please, Your Lordship? That's I file a application, my Lordships, for recall of appointment order, my Lord.
Recall of
19 February order that to appointment of arbitrator, my Lord. The two things which is not to brought to the 11 section 11 appointment code, my Lord. That one arising out of the same agreement, one final decree was done by the parties of the same agreement was not before this honorable court.
final decree was drawn.
This is there is a agreement was signed, my Lord, in 2016. Thereafter, a the partition suit filed by the arising out of same agreement before the civil court, my Lord. Puri.
What was the nature of the agreement?
Lord, the collaboration agreement. This I am the landowner, and there is a land.
So what it has got to do with the partition?
Lord, what I am saying, Lord, thereafter, Lord, the after final decree was done in 2018, Lord, after 7 years, they come a MOU which has no arbitration clause, and after knowing that I have instituted a suit that this same MOU is, Lord, MOU is by means of fraud, and also these.
It been declared that this MOU is fraud is being declared as void. Has it been done?
Lord, issue was notice was issued, my Lord, before the civil court, my Lord. What I am saying to all the claims are arising out of that MOU, which is no arbitration clause, my Lord. Once, my Lord, my humble submission, your Lordship.
Is it a supplemental agreement or the parent agreement substituting the original agreement?
My Lord, this is substituting original agreement, my Lord.
The superseding the original?
Yes, yes, my Lord. Right, which I say that we have never signed that document, and which was on 2000, the stamp paper was purchased on 2012, my Lord, and it was signed and it was executed 2016, and after that, when there is a partition suit was filed, it is not before the court also. It was only
partition has a different connotation, sir. It is nothing. It is amongst the co-sharers, whether they want to separate their shares is a different connotation.
Yes,
See, all the parties have agreed.
Yes, Lordship.
Agreed to
a compromise
to execute whatever. They are bound by the agreement.
Lord, Lord, what I am saying, Lord, that the basis of the MOU which has invoked, Lord, the appointment of.
What was the nature of the job to be done under the parent agreement?
Lord, the parent agreement, this is to be, they have to construct a building, Lord. In my, there is a building share of that I am the landowner, I am entitled to 50%, they are entitled to 50%.
So it's a development agreement.
Development agreement.
Say the development agreement.
Agreed, Lord.
Now, if it is a development agreement and all the co-sharers, they have signed.
Yes, Lord.
Even if there has been a separation.
Yes, Lord.
Does it impinge upon the agreement because they are bound by the agreement?
The original agreement
entitled to share their 50% of the constructed area in the same manner as that of the decree.
Yes, Miller. Their decree is done, Miller. The 19, Miller. The difficulty is, Miller, the subsequent MOU which we have not signed, Miller. Miller, my right, Miller.
What is the subsequent MOU?
Miller, that
missing the percentage.
All the liability has a subsequent MOU which was signed, Miller, by my the opposite party number 1, who is my elder brother, along with the Miller, the promoter. he has, my lord, without any our putting signature, they said that all taken liability assets has been taken rights, my lord, from, my lord, the financial liability, all the things has been taken by of the said MMO, which has never, my lord.
What's financial liability? I do not understand. It's a simple development agreement. What financial liability?
Yes, sir. Financial liability, my lord, regarding approval, my lord, construction materials, all the things.
Financial. That's he's a developer.
Yes, lord.
He has to spend the entire money.
Yes, lord.
Your contribution to the project is the land.
Yes, lord. But exactly, my lord. This
then he will make a constructions, and whatever the construction that would come, 50% that will go to him. 50% will go to you.
Milord, that Milord, already, Milord, this has been passed in premium by this aim.
What preliminary? I do not know.
Milord, your lordship kindly, I have annexed that. Your lordship kindly, that's MU, your lordship page 37. Your lordship, this IA.
Page?
Annex A by 3, your lordships.
What is saying?
A by 3, Milord, flag B, your lordship, the recall application, Milord.
This was very much there also as a document application.
Yes, the Honorable Court has your lordships kindly.
This was very much there application which was filed by the petitioner.
Yes, I'm submitting, Milord. Your lordship kindly see
whether he appeared on the day when the arbitration was.
Yes, Milord.
He appeared.
Yes,
they have entered appearance.
Milord, your lordship can.
No, why you did not take that?
Yes, you have taken
the case of a recalling.
Your lordship, your lordship has took note of paragraph 3 of my appointment order. That is your lordship, 11 February 2015.
Yes. What?
Your lordship, paragraph 2.
3 of?
Paragraph 2 of your lordship, original appointment order, your lordship.
Which?
19 February 2025. Order number 3.
19 February
2025.
Yes.
Your lordship.
This is not to be called.
Just like this.
Your lordship, paragraph 3, your lordship. Paragraph 2, your lordship.
Yes.
Mr. Learned Advocate appear from the opposite party and Mr. Mahanti Learned Advocate for the opposite party 2 to 5. The submission that is that if all dispute have been arisen, it is in respect of memorandum about understanding 16 June 2024.
Yes.
On the query, Mr. Patnaik is firm in his contention that dispute and difference have arisen under the collaboration agreement to all the parties. Milord.
So,
Milord, my humble submission, if lordship.
Can it be recalled? It's a case of a recall.
Milord, my subject to lordship 2 submission, Milord. Milord, once, Milord, the problem is that, Milord, Milord, 16, Milord, once a
the problem is the law.
Milord,
the problem is the law.
Milord, once the
is it a case of a recall under what provision the recall can be done?
Exactly, Milord, that can be your lordship. That is after the SBB co, Milord. This is a Milord the judicial proceeding is the article under 215 recall, Milord.
Limited. No.
The court of record article under.
Yes, it is no longer administrative order. It is a judicial order. No. So for a appeal.
No, Milord, that
is a judicial order.
Milord, so if it is judicial order, the court of record under article 215, the court can recall, Milord.
Inherent powers to recall.
Milord, that
I have to that.
Milord, that I have Milord, I have first of all query.
Recall can be made.
Milord,
if you want to achieve something in the guise of a recall, that is not permissible in law.
Milord,
the Supreme Court has deprecated such exercise.
Milord,
that if you really seek a review in the guise of a recall or a clarification or a modification, that is not permissible.
Milord,
you are really seeking a review of the order.
Yes, Lord.
That's the purpose.
Yes, Lord.
That is not permissible.
Milord, one more submission, Milord. The reference, Milord, your lordship wants the referred, Milord. Once the court is referral court matter referred to the Milord, the arbitrator. The arbitrator, Milord, that wise I am saying the MO is.
Can after the disposing of the matter go into all those integrity?
I am only I am humbly praying, Milord. The arbitrator, even I file a section 16 before the jurisdiction of arbitrator.
There is no
my difficulty also one submission, a last submission. They will not influence by this appointment order, Milord. Referral appointment.
What? Even if you go, the law will take its own course. I am not going to advise them, nor to you.
No,
you know better what is.
No, Milord.
No.
So
This is an application captioned as an application for recalling an order dated 19/2/2025, by which an application for appointment of an arbitrator was disposed of. Stop. While considering an application under Section 11 of the Arbitration and Conciliation Act 1996, the preceding Chief Justice found that the dispute so raised comes within the ambit of an arbitration agreement and dispose of the said proceedings by appointing an arbitrator. Although the order dated 19/2/2025 was passed in presence of the parties, yet the opposite parties have taken out the instant interlocutory application seeking recall of the said order dated 19/2/2025. The counsel for the applicant sought to convince this court that the objection was raised at the time of hearing of the application for appointment of the arbitrator, to the extent that the memorandum of understanding subsequently entered into is bereft of any arbitration agreement, the court should not proceed to appoint the arbitrator. It is not in dispute that the original agreement, development agreement entered into by and between the parties contained an arbitration clause. The subsequent developments in relation to the assertion of their respective undivided rights in respect of the properties cannot dilute the agreement, if already signed by the parties. Whether a subsequent MOU has any bearing or not is a matter to be decided by an arbitral tribunal. And in the event the petitioner feels that the dispute is outside the purview of the arbitration agreement, he can take recourse to law as permissible. It is no longer res integra that the court shall not permit the litigant to achieve a thing which he cannot achieve, to achieve a thing indirectly which he cannot achieve directly. Though I am conscious of the proposition of law that the nomenclature of an application is not a determinant factor, as the court is required to look into the substance thereof, yet the court cannot shut its eyes to the latent object, the latent intention to arrive at the patent decision. So stop. The litigant shall not be permitted to seek review in the garb of an application for modification, clarification, and recall. Stop. After considering the pleadings made in the instant application and upon hearing the parties, we find that the real intention of the applicant is to seek review of an order dated 19/2/2025 in the garb of an application for recall, which in my opinion is not permissible. The application is thus dismissed.
Item number 4.
Item 4, I seek time. We are the opposite party, and the first time it was come to today we are appearing. So one date may be given.
2 weeks time.
Item number 5.
Item number 5, the opposite party number 1 had died. I had filed an application for substitution.
Within time, 90
Yes,
days.
and your lordship had also issued notice on the question of substitution. Allowing the same, your lordship had it was within time.
No, we have already allowed the application for substitution.
My lord, the registry,
this has to be issued on the substitution.
Has been issued. The registry says that the AD or undelivered notice has not turned.
The service is not complete. Let the matter be listed after 2 weeks.
My lord, I request your lordship may direct the registry to place the tracking report. Grateful. 6 is also same.
Yes, same.
Item 7.
Things matter. For the convenience of the court, we have given a short note at flag C. Here, if your lordship wants, the arbitration clause is at page 24, clause 12.
Flag B.
Flag C is the note where short points governing the case have been. Your lordship had heard me, my lords, in this. The arbitration clause is at page 24. 24. Annexure 1, page 24, clause 12. We have also given clean copies subsequently.
Have you given a neatly typed copy?
Yes, we have given. We have given of Annexure 1 as well as the entire brief also we have thereafter given a very clean copy.
What is the internal page of the contract, sir?
Internal page 24, Annexure 1, clause 12.
Yes.
Neat type copy.
What is the nature of the agreement?
Nature of, my lords, it's a raising contract agreement between the present petitioner and the OP number 1. And if your lordships would see, the notice invoking arbitration has been given at
Now, this is the deemed arbitrator.
Yes, deemed arbitrator. One of them is our own CA. That is not permissible now, and the other person has died.
Schedule being appended.
My lords. Section 12.
And what about the other?
Other one has died. So the only course is here. Now, if your lordship would see, we had.
Who is for the other side?
He's appearing online, I believe.
Yes.
Well, it's their counter. Earlier, we had filed this before the Madras High Court. The Madras High Court dismissed it on the ground of territorial jurisdiction. Here, their counter, if your lordship wants to see what they are saying, certain paragraphs would be very relevant. Para 10 of their counter at flag A, my lords. That would be internal page 4 of the counter. Paragraph 10 onwards.
That's the case. They have made out a case of a fraud.
My lords.
So that fraud can also be
gone into, my lords. That's one. And regarding territorial jurisdiction,
how can they have raised that objection before the Madras High Court?
And they succeeded there.
They succeeded. So
here also again they are saying that Orissa doesn't have, but some of the
which High Court has.
Some paragraphs would be interesting, my lords. Para 12, if your lordship sees, para 12 would be relevant.
They said that which High Court has.
No, they initially said this court doesn't have. Then ultimately, towards the end of para 12, they go on to say that everything is situated in Orissa, making this court an inconvenient and inappropriate forum for adjudication.
Everything is situated in Orissa.
Yes. And then they say that it's inconvenient here. So they basically, now they have...
This agreement, this mining is situated where? In Odisha?
In Odisha. So
yes,
they want to block every legitimate endeavor of ours for arbitration. That's why I wanted to show this.
And what is the dispute?
Dispute is relating to a raising contract where we were supposed to extract minerals, for the balance period and for the renewed or the revival period. And since thereafter they didn't cooperate with us, we have the cost that we have incurred that we are wanting to recover from them.
Is the
Lordship,
unliquidated,
there are two fundamental objections that I have to it.
unliquidated damage?
Unliquidated. And for convenience, I have given a short note at flag C, where everything has been listed, the clause, their objection which I placed, and recent judgments of the Honorable Supreme Court, where they say that this is basically a regime of minimal intervention at 11th stage, including 2025 minutes. All these things have to be left for the Honorable Arbitrator to decide. Those judgments, recent judgments, I have it's a part at flag C.
Yes.
Lordship, there are two fundamental objections to this. If your Lordship would refer to the raising contract, the way on the previous occasion also your Lordship had pointed out that this raising contract is no longer in validity.
But if it is a dispute arising from that raising contract, does it mean then I have to rewrite the law?
Lordship, I'll let you. Lordship, if your Lordship would refer to page number 20.
I'm talking about giving a hypothetical example. Suppose in case of a lease between the lessor and the lessee, and if certain obligations have been given therein, the lease has come to an end, but the obligation in relation to a contractual period remain, and the dispute.
Lordship, that is not the position at all. If your Lordship would refer to the validity period, that is one part. Your Lordship had rightly pointed out at the previous occasion that this lease is no longer valid. Secondly, if your Lordship refer to the notice,
let us see. Suppose a contract is for a period of 12 months, and in terms of the contract, the bills are raised. The contract has come to an end. The bills are...
That is not the consideration. If your Lordship would refer to the the arbitrable dispute that they have pointed out, that is at paragraph 5, 6, and 7 of the section 21 notice, they have clearly pointed out that FIR and litigations filed by us.
The scrutiny of the High Court under section 11 is very limited. It does not go and find the veracity, the sanctity, the ultimate.
Your Lordship have to decide whether there is an arbitrable dispute or not.
Dispute.
In case of an
out of a contract.
Lordship, there is no arbitrable.
All the plea take before the arbitrator.
Lordship, allow me just 5 minutes. I'll explain, Lordship.
Explain.
Lordship, the paragraph 5, 6, and 7 of the notice categorically point out what they are considering as the disputed provisions, Lordship, which are FIR. We have filed an FIR against some person who is a power of attorney holder. He is not associated.
Just wait. That's the whole difficulty of the virtual hearing. That the moment I ask you a question, you continue arguing.
Annexure 8.
Obviously, because of the time lapse.
Annexure 8.
Where is the section 21 notice?
Annexure 8 at page 86.
I am referring particularly to page 88, Lordship.
You are referring, you have memorized it. We have to read it. So let us see. Now you tell me which paragraph you are referring.
Paragraph 5, Lordship.
5. So give me a chance to read.
That would be at page 18. Page 18.
Yes.
Lordship, in all three paragraphs, paragraph 5, 6, and 7, they have pointed out what their difficulty is. What we are saying, Lordship, this FIR, these litigations are all filed against the power of attorney holder. They are not against the petitioner per se.
I am asking you, sir. I'm simply asking you, sir, is he a party to an agreement which
He
contains
is
an
not the party to the agreement.
is not
Power of attorney holder is not the party to the agreement.
is he having a derivative title from an
No,
agreement?
your lordship. Lordship,
Is-
only reason the power of attorney holder.
Show us the agreement. Who are the parties to the agreement?
Parties to the agreement, page number 20, your lordship.
18.
This is
18,
between
lordship.
Dayal Agarwal
and Anand Granites.
and
Anand
Anand
Granite.
Granite. These are the only two parties, sir.
who are you?
He's Prabhu Dayal Agarwal.
Lordship, I appear for Prabhu Dayal Agarwal.
I'm Anand Granite.
No, you are Anand Kumar.
No, I'm Anand Granite Exports.
Oh, you are Anand Granite. Then you are a party to the agreement.
Yes, and he's for Prabhu
Lordship,
Dayal.
but the litigations that we have filed as per their notice, that litigations are against power of attorney holder. They are not against Anand Granite.
Sir, have you seen this 21 notice? He says that because of your these misdeeds, he has suffered a loss. He could not.
Lordship, that is not the situation at all. That is what we are trying. Allow me to categorize the facts as they are.
Can he not? I'm asking you.
Lordship, there was some break in the voice. I wasn't able to comprehend what Lordship said.
You should, because he's not saying that something which has been done against his power attorney holder or against whom. He simply says that this is a raising contract. This contract contains several stipulations in form of the terms and conditions. You have violated any terms and conditions which resulted into a loss suffered by him. He wanted to recover the loss and the damages. Can he not?
Lordship, there is no situation in which they have pointed out what is the loss that they have suffered. Allow me to reiterate the facts, Lordship. Allow me to reiterate the facts. They were, Lordship, they were appointed as the contractors to the mine. They were to be paid 10% of the ore value. Rest was to come to me. I have suffered. They
trying to argue.
They contacted Gayatri.
You are trying to argue.
They were very well aware.
You are trying to argue on merit. We are not going to decide. I am not going to decide on merit. Ultimately,
that is not the merit. Lordship, those are not the merits on which the arbitration. I am only talking about whether the arbitration tribunal can decide this particular factor. The arbitration tribunal is very well limited. They cannot stop me from filing litigations.
The judgment of the Supreme Court, whether it is a dispute arising out of the agreement is a valid one, and it is arbitration agreement is a valid one. Is there? Will not go.
IPA, a consortium versus GAIL India. We are falling directly in that. There is no arbitrable dispute. The agreement has expired. This cannot be considered a valid agreement, Lordship.
That is fair. Your Lordship may leave it for the arbitrator to take a call. That
is what is required. There's a law which is there. He will take up all.
If that is the case, Lordship, I might not be able to explain it all via VC. Allow me 2 weeks' time. I'll be there physically.
No, you'll have to. That is what I feel, because sometimes there is a technical glitch. I cannot hear you properly. You can respond. I am making certain queries. You continue arguing because of the time lapse, because my voice reaches to you a bit later. Come, argue.
Lordship,
Monday you argue. I will sit. Argue. Let me see.
Lordship, I'll not be. I'll not be here. Be able to reach. If it can be fixed on 18th, 19th,
where are you?
of July, I'll be.
Where are you?
Lordship, I am. I reside in Delhi, Lordship, but I have a few matters in Chennai during this period, and Kohima bench of Nagaland.
Delhi. Very good connectivity. Come on Monday. Argue.
Lordship, it would not be possible. I'll be in Kohima, Nagaland on Monday.
So that's more nearer. In the Seven Sisters, argue, come. On Tuesday, come. Argue.
Lordship, it is a Lordship, 18th of July, I'll be there. I'll argue physically, Lordship.
No 18th July business. And that is a non-miscellaneous day in the Delhi. Don't worry. Come on 18th. Monday, I can understand, is a
18th of July, Lordship.
Busy. Come on.
No, Lordship, Delhi has, the Supreme Court, as it is on vacation for the period. My concern is not that court.
You come on Tuesday. Come.
Lordship, that would be impossible. Lordship, that would be a rather difficult.
You can't quote. You treat the court for a right. The court will tune on your convenience. You'll have to.
Lordship, it's not about the convenience. It's about the justice that Lordship can deliver.
What we are giving, but you can't take advantage of that. I say,
Lordship, that is.
Come on, Wednesday. Come. Wednesday, come.
Yes. Lordship, it's rather difficult for me, Lordship.
Let your client engage. Take a call. What to be done? No, sir. This is not expected, sir. There's somebody at the distance place. We always encourage, but that does not mean
he will. Can it be on 30th?
Compel us 30th. To just succumb or succeed to his.
Lordship, can it be on 30th? It's a Monday. I'll be there.
Come on, Monday 30th. We are ready. Come on, 30th.
Yes. Very well. Very well.
The counsel for the matter was heard on a virtual mode, but because of some technical glitch, I find that the proper hearing could not be conducted. To which the counsel for the opposite party submits that he will make himself available physically if the matter is fixed on the other day. Stop. On his request, let this matter be fixed on 30th to be taken up. Which one? Is a morning flight or?
Lordship, I'll manage. Anytime the Lordship fix.
At 2. 2. At 2 p.m.
Yes. Lordship.
Very no difficult.
We are grateful to you. Item number 8.
Pardon me, my lord. I am on VC, my lord. Pardon me. Sir, I beg to appeal for the opposite party, my lord. Hindustan Aeronautics Limited.
Family, please, your lordship.
I'm yet to get the copy of the petition, my lord. And I am permitted.
The copy, my lord, the notices were issued, but the noting states that neither the postal lady nor the delivery report.
Now he's appearing. So you are.
Yes, my lord. I am for Hindustan Aeronautics Limited, my lord.
He's from Koraput, as far as I know.
My lord. I'm at Koraput, but in the meantime, I will file that vocal as well.
Sir, then who will accept the copy on your behalf?
I will make the arrangements, my lord. I will get it done. I will get it collected.
In accordance to the
Mr. T.N. Murthy.
T. Narayana Murthy, my lord.
T.
Narayana Murthy.
Yes. Murthy, Kamal Learned Advocate appears on behalf of the opposite parties and submits that the copy of an application under Section 11 of the Arbitration and Conciliation Act 1996 has not been served upon his client. Stop. We find from the office note that the service is not complete as the acknowledgement due card has not returned, showing the due service upon the opposite parties. Since the appearance has already been made, in order to expedite the disposal, the hearing of the matter, the counsel for the advocate and record of the appellant is directed. A petitioner is directed to serve the copy upon Mr. Murthy or his advocate and record to be intimated to the advocate and record of the petitioner. When, sir? By Monday?
Beg your pardon.
Can you make an arrangement by Monday so that the service will be affected by Monday?
Yes, my lord. I hope so. I can.
Yes,
I will
Monday.
make it.
Give a date. On 4th. List the matter on immediately thereafter.
Yes, ma'am.
Available Friday, that is on
4th July.
Sir, 4th July, the matter is fixed.
Obliged, my lord.
Item 9, West.
Yes.
May I please lordship matters? This is section under section 11(6)(c), that is section 14 and 15. Innocuous pair malice substitution of
The mandate of the arbitrator. What has happened?
State administration, that arbitration tribunal.
Where is the other side?
Other side, there's one. And OP2 is the main opposite party.
And then have to serve.
I've already served my lords the copy.
Somebody is appearing.
Last time he appeared, I served the copy, but I don't see him now. One thing is that the case is pending since 2005 because State Administrative Tribunal, which is not functioning, the quorum is not there. And the similar matter, the coordinate bench mallards have already appointed 6.
Mr. BP Tripathi.
Yes, mallards. So I've already served the copy and he is aware of mallards.
Where is he?
Not here.
Can you secure his presence? He is the practitioner here.
He is here, but he goes often outside also. But I don't know whether.
Come on 30th and give the notice to him.
I'll
will be taken up at 2 p.m. on 30th.
30th, 2 p.m. Mallards. I'll inform mallards. Item 10. Oblige mallards.
In the motion it says 18 has happened.
Oh. His service is not complete on 4th.
Item 11.
Item 11, let's move it up.
Item 11, my lord. I have not received any instruction today. Talk to the manager. Lordship grant me 7 more days time. I'll obtain.
4th on the prayer.
Item 12.
Supposed to file a response while filing it today, giving copy to my friend, and next available bench, lordship may take it.
You are for the opposite party as well.
Opposite party.
It is submitted by the counsel for the opposite party that the copy of the counter affidavit has been served upon the learned advocate appearing for the petitioner in court today. The petitioner is at liberty to file a rejoinder if there be any within 10 days from date. This is the matter on 4th.
During 13 minutes.
13, it is with Mr. Maran, he is not well. So,
he's got personal ground.
Item 14.
Record that, Mr. Maran, please.
My lords, in item number 14, some time may be granted for filing objections in the matter, my lords.
Why you did not? Was the opportunity given to you?
On the first occasion, notices were issued, my lords.
Oh, there is no opportunity.
3 weeks, my lords. 3 weeks, my
3
lords.
weeks. Rejoinder? If any, within a week. Matter to appear after 4 weeks. Give.
18th. Item 15.
My lord, taking my lord's leave to appear online. My lord.
Yes, sir.
The reply has come, my lord. In this case, reply has also come, my lord. There's no much dispute, my lord. Only about that claims are not maintainable. That's all, my lord.
My lords,
On merit, if you can.
No, not on merit, my lords. Only on the notice, my lords. As per the arbitration clause, there is no we are actually challenging the notice, my lords, here, my lords. Because if I may read
the notice under section 21.
Yes, my lords. It is not as the clause, my lords. The only submission, my lords. If I may read the clause, my lords, once.
Yes.
The clause 3.57, my lords.
Page.
It is at page number 18 of the application.
Just a minute.
My lord, the last paragraph, the principal secretary so and so, he may communicate his decision within 45 days after that, my lords. In case the contract is still not satisfied, he will take recourse to arbitration and conciliation, and the dispute will be resolved as per the Arbitration and Conciliation Act. My lords, the clause does not mention the number of arbitrators. The notice.
So the section 11 is taking care of this.
Yes, my lord. Only
And
thing is
the
that they,
law is also there that it should be in an even number, not in a odd. Sorry, in the odd number, not in the even number.
yes, my
In
lords.
that eventuality, my lord, section 10 will come into play. It says that if numbers are not mentioned, then there will be sole arbitrator.
My lords, only section 10, it should be sole arbitrator.
I don't mind, my lord. I leave it upon your lordship.
To the court,
Yes,
whether the sole arbitration or a panel of arbitrators.
my lord, section 2, if I may read, my lord.
That's the court will take care of that.
My lords, 10(2), if I may, my lords.
Give me the arbitration and conciliation there. Yes.
Failing determination referred to in subsection 1, the arbitral tribunal consists of a sole arbitrator.
Yes.
My lords, in the notice they have referred, they have.
But in sole arbitration, where is the? That's why I say it is just left to the appointing authority that whether it's sole or now give me the name.
My lord, I subject to my friend's approval, my lord, Justice S. Pujari, if have no objection, my lord, to.
What my senior is saying.
My lords, I have to take instructions, my lords.
What is? Sorry, then.
With respect to.
This is what I adopt. Otherwise,
I bow down, my lord.
Prerogative.
My lords,
Yes,
the lordship may
My
decide.
prerogative, but still I am handing over to you. What is the total claim, sir?
Well, it will be around 85 crore as per the notice of 21.
Can be a retired judge of a high court.
Yes,
So find any name. Yes. Both of you.
Well, Justice Patnaik, Justice Paramarth Patnaik, Justice BP Das, Justice
Your
S. Pujari.
Let both the sides look at it.
Justice A.K. Rath. Justice A.K. Rath.
My lord, then I will leave upon your lordship, my lord. Then I think some reservation with Justice Rath. I'm so sorry, my lord. Nothing, but there is, I mean, the clients probably has some consultation or something, my lord. There is just reservation. Just, I mean.
Honorable Dr. Justice A.K. Rath, my lords.
Yes.
My lord, in fact, anyone else, my lord, I leave it upon your lordship.
What anyone else then?
Then, my lord, Justice S. Pujari.
No. Anyone else then who?
I think my friend is referring the name of Justice Dr. Rath.
Yes.
Probably my clients has some reservation. My lord, I think some opinion or I don't know, but there was some objection raised.
No difficulty. We are searching another name.
My lords may decide, my lords.
We are searching another name.
We leave it upon your lordship. Anyone. Madam, do you have any objection about Justice Pujari and Justice Das, Justice Patnaik, Justice Mohanty, Indrajit Mohanty?
My lords, for any name, my lords, I take instructions, my lords.
The problem is that, my lord, we will not, my lord. So I leave it upon your lordship, my lord. We will certainly keep on objecting.
We are appointing Justice C.R. Das.
Yes. Deeply obliged. Deeply obliged. My lord, the fee will be as per Schedule 4, my lord.
Yes. That is, I believe.
My lord, it is not written there, so my lord, I think that is also, my lord, the sole arbitrator, it will come down around, my lord, 37.25 lakhs. So it is also good, my lord. The fee part is good.
An agreement for construction of a distribution system within bracket minus, sub-minus, and Rodanga tail distributory of the Bhuvan branch canal of Rengali irrigation project phase 2 under package number B22 was entered into between the parties to the contract on not written when executed. Anyhow, date of commencement I am writing on 2/8/2018, stipulating the completion of the work by 1st August 2020. The said agreement contains an arbitration clause. The said agreement, apart from containing the arbitration clause, also contained the mechanism of settlement of the disputes pre-arbitration stage. Full stop. The dispute arose between the parties, and the same is duly communicated by the petitioner to the opposite party in compliance of the mandate given under Section 21 of the Arbitration and Conciliation Act 1996. Since the opposite party did not refer the name of the arbitrator to adjudicate the dispute so raised, the instant application is taken out for appointment of an arbitrator. Where is your counter affidavit?
It's in form of an affidavit which was filed on
Where is that?
3rd May 2025, my lords.
Oh, yes. It's not on a board.
Filed on 23rd.
The contesting opposite party filed a counterclaim on 23rd
23rd May
2025. And a copy thereof has already been served upon the petitioner. Taking a plea,
Para 14.
which is
Para 14 members.
which is basically founded upon the invalidity and all the invalidity of the notice raising a dispute. The tenet of the averments made in the said the counter affidavit is hovering around the merit of the claim raised by the petitioner, which in our opinion cannot be decided at the time of the appointment of an arbitrator. Whether the notice is invoking the arbitration being defective is a technical plea which this court feels should not be taken into, should not be gone into, provided the dispute so raised comes within the peripheral and or ambit of the arbitration agreement. The notice is intended under Section 21 to communicate that the dispute has arisen and such dispute is required to be adjudicated by an arbitration, and therefore the merit of the dispute cannot act as a deterrent at the time of the appointment of an arbitrator. The moment the court finds that the dispute has arisen from a contract or agreement, and the parties have chosen to adjudicate the dispute through an arbitral mechanism, there is no fetter on the part of the court to appoint the arbitrator. We therefore, the application is after considering the nature of the disputes and the claims to raise, Justice C.R. Das, within bracket RETD, retired, is appointed as a sole arbitrator to decide the disputes between the parties. The remuneration of the special officer shall be paid in terms of Schedule 4,
my lord,
to the Section 29A, Schedule 4 of the said Act. The application is thus disposed of.
deeply obliged.
Deeply obliged,
Thank
Your
you.
Lordship.
Yes.